Yes. Put your mic.
With your Lordship's kind indulgence, I beg to mention item 28. My Lord, I am in an embarrassing position to say, adjourn the matter of 2013. My Lord, your Lordship, kindly accommodate me for 2-3 days only. Next week, any date your Lordship can fix.
Why so?
My Lord, due to my certain personal difficulty, I could not lay my hand to this bill. That's the only reason.
Mr. Doctor, I will give you a chance to reply on next.
Yes, yes, that will also do.
But I won't adjourn the
Yes,
matter
yes.
because it won't look nice for
All right,
2013 match.
My Lord, I am much conscious of that position. That's the reason.
Because otherwise it looks bad.
Yes, I do accept. Obliged.
May I please, your Lordship? Lordship, I need to mention item number 31, Lordship. 31, Lordship, of hearing this, Lordship. This matter, Lordship, relating to transfer, Lordship, and the petitioner already have, Lordship,
Infractious.
Lordship, instructed.
Heard, Mr.
I use Lordship, on behalf of HRA, Lordship. My name is not there, Lordship.
None of these people are here. F.U. Barbuya, H. Ali, A. Ahmed.
They are on legs, Lordship. They are on legs, Lordship.
Get them.
Lordship.
Not at your.
Lordship. Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 25, your Lordship. The instructing counsel is under bereavement, your Lordship.
Who?
Mr. Patwari, your Lord. The standing counsel of Patwari University.
It's that matter pertaining to
I remember. That matter pertains to this
4.2.9. Your Lordship can have it next week, any date, subject to my Lord's board permitting.
Next week to 23rd and 25th, there are a lot of matters fixed.
The week next.
We'll have it on 30th.
Lordship, can be on for 3rd, your Lordship. Can it be on 3rd of June, your Lordship? 1st of June, your Lordship.
We'll have it on 1st of June.
Lordship. Much Lordship.
Mr. Your name, your name?
Lordship, I'm N. Gautam, your Lordship, for respondent number 3, 4, and 5, your Lordship.
Mr. N. Bodlo, the Learned Council, hearing for the response number 3, 4, and 5, submits that the instructing counsel, Mr. J. Patwari, is in bereavement, taking into account the same, that the matter be again listed on 1st of June 2020.
Much
My Lord, I beg to mention item number 32, my Lord. Additional Advocate General K. Kumar was supposed to appear in this matter. However, his son,
Who?
K. Kumar,
Can't help it.
his son got admitted in the hospital yesterday.
2015 matter, no, sorry.
2019, my Lord.
Oh, 33.
15, I'm sorry.
Then 15 matter doesn't look.
Short date, my Lord, 1 or 2 days, my Lord may accommodate.
You see, I told the senior counsel also. I won't grant it.
My Lord, tomorrow or day after tomorrow,
No.
my Lord may accommodate to the
I
emergency.
can give you, provided you do it on this Saturday.
This
Want to
Saturday,
do it on Saturday? You have to come to the court.
for this one matter. No, my Lord. Saturday is which date? Any date, any short date, my Lord. Saturday is fine. I'll talk to my senior.
On
He
Saturday.
can-
Remember, the court has to open because of you.
Just
You're
have a
ready
word
to
with
do
my
that.
senior. I'll just have a word with my senior.
Sorry. No.
Saturday is fine then, my Lord.
No agenda. Yes.
Item number 31, Lordship, this matter has become infractor.
You are there?
Yes, my name is there.
Heard, Mr.
A. Ahmed.
A. Ahmed, the learned counsel appears on behalf of the petitioner. Mr. T. Vora appears on behalf of the respondent state. The learned counsel for the petitioner submits that the petition has become infructuous. Accordingly, the petition stands.
Interim order may be vacated. Interim order may be vacated.
Interim order so far stands.
Obliged.
Obliged.
Item number 1 for motion.
What happened? First and foremost, this matter has come up on a, today is what? 18th. Petitioner is not interested. What is the matter about Mr. Burwa?
They're claiming for compassionate family pension, Lordship.
Hmm.
So earlier round of litigation, they have approached this honorable court that they face 50 Lordship. In that proceeding, Lordship, director of pension was not made a party, so certain direction was there.
Is directed to submit a detailed representation stating all the relevant facts and produce all the relevant materials which may indicate that she is unmarried, dependent daughter of the deceased so and so, and upon such evidence being submitted, the director shall pass a reason or if necessary by giving a hearing to the reason or. Okay, then
So when the matter came to the director of pension, so they are saying that the petitioner attained the age of 21 years on 7/4/2017 itself. So
but the entitlement is not on the age. The entitlement is unmarried.
not that time when she attained the age of majority on 7/4/2017.
That was
That notification was not came into force.
okay.
Unmarried
But now
dependent
with the
daughter.
notification coming in,
Yes, Lord. On
Wouldn't she be entitled
9/8/2018.
wouldn't she be entitled to if she is unmarried?
Notification came into force on 9/8/2018.
Understood.
Yes, Lord.
But are you going to count on the basis of the date, that date? Or are you going to count as on now?
We have to count at the date as on now, Lord.
As of now, she is otherwise entitled to if she is unmarried, dependent daughter. These are verifications which needs to be carried out.
Lordship is,
That order may not be wrong because that was the law at that point of time.
Lordship.
But as of now, can this court say that in view of the change in the law now, where a person would be entitled to, or is the entitlement goes upon the death of the person concerned?
And moreover, Lordship, in this petition, Lordship, yes,
There was a direction to file some affidavits.
they were directed to file some additional affidavit.
Inform as to why he had taken a view which is substantially different from the adjudication made. By earlier direction, we have had taken a substantial. The director comes forward before this court with an explanation that he is not aware of the judgment. If that is so, at least Reza is aware of the judgment. Given an opportunity to do the need on the prayer of Ms. A.M.N. learning of the matter stands adjourned. She is allowed to file an ear complying the order dated wherein she had filed the detailed representation before the director of the registry. She is allowed to submit her additional affidavit in terms with the order dated 12. So they have not filed it. They have not filed this affidavit.
I have not received, Lord.
No, it is not filed. None appears on behalf of the petitioner. None appears on behalf of the petitioner on call. This court, by an order dated 13/6/2022, Mr. S.R. Borua appears for the Director of Pension. This court, by an order dated 13/6/2022, directed the petitioner to file an additional affidavit to the effect that she had submitted the detailed representation before the Director of Elementary Education to the effect that she is an unmarried daughter of the deceased Abdul Khalik Khan. Thereupon, the matter has again was listed on 3/5/2023. However, no additional affidavit was filed, for which this court granted a further chance to file the same on 18/5/2023. Today also, neither the petitioner is represented nor any additional affidavit has been filed. Taking into account the above, it seems that the petitioner is not interested in respect to the instant proceedings. Accordingly, the petition stands dismissed on non-prosecution.
Lordship, already earlier order was there to Captain Evans the PPO, Lordship. Right, order dated 14/02/2022. Accordingly, we have communicated to the Treasury Officer to Captain Evans the PPO.
Why? Be that as it may, the Director of Pension shall take appropriate steps in accordance with law and if the petitioner is otherwise entitled to, grant the benefit of the compassionate family pension to the petitioner.
Obliged.
Item number 2 to 13 for admission.
Where is-
Yes,
My lord had heard these matters. One issue, my lord, which had crept up was, and my lord wanted us to address on that issue.
Gwalpara, regarding that Gwalpara and Dibrugarh part, my lord, that inspection is on the way. Let them start regarding the other issues, my lord, that can be delivered.
Only on that issue I would like to,
Yes,
because, my lord, what they have now, it has boiled down to, is that the director's approval was not there. That's the screening committee is one of the recommendations of the screening committee. So this is bad. So they have taken up a plea now because the director's approval was not there. My lord, so that appointments were bad. These pleas were taken, my lord, we were appointed in 2005. These pleas were taken sometime in 2017 towards the end, 18. Now, what is the position? How the matter, just my lord, in the records, what is there? I'm just checking. My lord, the appointment orders, my lord, would find were given to all, including the director of director of health and family welfare. Thereafter to the treasury officer, and my lord, to the AG and all, whatever is there. Now, after the my lord SLC was done away with, because our appointments took place under the regime of the SLC, state level empowered. After that thing was done away with, and my lord, the new formula of SIU was brought in. There is an interesting thing in between, which the state government did. One, the state government SIU department in the secretariat and my lord, the directorate areas examine the necessity of carrying out with the posts that were there. My lord, say in the director of health services, there were 10 posts of LDA vacant, not filled up before 2001 and thereafter. The SIU, I'll show from the records, the SIU carried out an exercise to determine whether these posts have to be there or required to be abolished under the FRBM Act. Similarly, for the district level posts, there was a committee meeting with the deputy commissioner at the Health of Affairs, and each and every department, the posts were examined. Thereafter, a decision was taken, had been arrived that these number of posts will keep, this number of posts will not. We were working at that point of time. And are these posts were also examined? Well, it should be deemed to have been examined on that exercise. And my lord, it was clear, because why I'm saying so, from 2005 onwards, our pay was being released by the treasury without any objection. Whereas the memorandums that have been issued, my lord, at that point of time, 2005 till August 2008, it requires that the treasury officer can disburse the amounts only if the conditions therein are fulfilled. So without any objections, our salary is being released, my lord, demonstrates the fact that we were not excess appointees. If we were excess appointees, that exercise in education department, my lord, has seen many were identified, then my lord taken out or subsequently regularized. Here, my lord, there was nothing done in our services. We were allowed to continue. So we were working, the persons who were there, they were working, my lord, in relation to the quota of seats or number of seats that or posts that were there. And my lord, our appointments had the requirements to be fulfilled. So the treasury officer was honoring the bills that were given. And for 13 years, now, my lord, I put it from a different point of view. The directors have to do it. How this is done, my lord.
But
My
Mr.
lord-
Talnaik, let us go into on a different tangent.
Lordship,
Why have you filed this requisition?
because, my lord, they have taken up out of the blue an exercise for, my lord, exercise to see whether our services are legal or illegal, validly appointed or invalidly appointed.
No,
Out of the blue.
You have out there challenged the termination of.
First, my lord, we challenged in the first round the notices because they were doing it without any. So they were on 2-3 rounds, my lord. Subsequently,
But now, at present,
now, my lord, we have challenged the termination order.
so this court is to look into as to whether the termination was right or wrong.
Lordship,
The termination has been done on the ground that the appointments were illegal.
Lordship,
The reason is two things. One, there was a ban out there, and the second is there was no approval from the director. That is
Gotcha.
another aspect.
Lordship.
So, in order to do so, this court have to hold that the termination is bad. This court has to hold that your appointments were right,
Lordship,
proper.
Lordship.
So, under such circumstances, you are to show me that the appointments were properly done.
Lordship.
So let us see on that.
My
Not
lord,
on the
first I have the
future
advertisement.
consequences which is
Lordship,
followed.
First, I have the I'll go sequential way. My lord, in an appointment, first thing is an advertisement that is available on the court. Then, my lord, the thing required is a select list that is available at least in 2-3 cases. My lord, that is available. Thereafter, the appointment orders signed by because these are district level posts. The joint director.
So
will sign.
here for grade 4, these are all grade 4.
Grade 4 post. my lord.
So for grade 4, there is no rules.
No.
So this will be done as per
Interview, my lord, oral
how
interview.
does an appointment happen?
It's as per the
appointment-
general rules, my lord. General rules. There is a general rules, my lord. The Assam Public Direct Recruitment to Class 3 and Class 4 Post Rules 1997.
Yes, even if my lord goes by that.
Yes, yes.
Service rules?
My lord, it's a
Direct
it's a
recruitment
manual.
rules, my
Page,
lord.
my lord, 115. Page 115. Same book. Then Lord, you will see rule number 3.
Okay. 1977 rule.
Yes,
1990.
rule 3, my lord. These rules shall apply only to those class 3, both technical and non-technical, and class 4 posts where there are no service rules, executive orders regulating the recruitment and condition of service and are not within the purview of the commission.
These rules shall not apply to the following cases: the posts in which recruitments are made as per the existing service, posts which are within the purview of the commission, the posts of teachers under the education department, the posts under the home department, posts of the establishment demand, posts excluded from the purview of these rules by general or special. So under such circumstances, you don't come within 1 to 6. Direct recruits shall be made on the basis of the recommendations made by a selection committee in accordance with the procedure hereinafter. Before the end of the year, the appointing authority shall make an assessment regarding the existing vacancies and the likely number of vacancies filled by direct recruitment during the next 12 years, and shall intimate the same to the selection committee together with the details of the reservation or reserve. Besides the vacancies giving details of the reservation or reserve. Commissioner, district level of it will come under the district level of it
It will come under
Yes,
district level.
district level.
to the deputy commissioner for the district in which the office of the appointing authority is situated. All divisional all employment exchange in case of divisional level such as public work, forest, etc. Deputy commissioner regional level shall, after considering the necessary mentioned we are concerned with selection committee of districts
District level. Because it is under the joint director.
5A. Would it come under 5A?
5A.
5A,
1A.
district level.
5-1. Yes.
51A1. Composition shall be the appointing authority or the senior most departmental officer available in the district where the vacancy arises. Officer belonging to the office under which the vacancy arises. Officer of the rank of PA and officer of the department under the department under which the vacancy arises. Of the definitive. It will be the selection committee. Who shall appoint? Where is the appointing power?
Well,
Power to appoint, where is it?
yes. in
My lord,
that-
we'll have,
Before that,
2A.
Lordship may kindly have a look at 5.
5 is selection committee. I'm saying about
Constitution of
six.
Selection Committee,
That
5
is
3.
okay. No. See,
Page 121. Page 121, sub-rule 3.
shall issue instructions on the namely the minimum accessible for the direct.
Administrative department will be the health department, my lord. So this part, my lord, in the present selection of Gwalpara and Dibrugarh, apparently is, my lord, missing. My lord, 5.3, it says, my lord, the administrative department shall issue instructions on the following namely, the administrative department will be the director or the government, my lord, and not the joint director.
Okay, no,
He may be the
No,
appointing
no, no.
authority.
I understand that, but you see, does it say out there that without, if the, just for example, the administrative authority does not do so, whether that will be bad?
That of course is not there in the rules.
So if it is
Any
not
rules,
done
my
so,
lord, that,
no,
that
that is
not
why
there.
I wanted to say, as to prior to issuing the appointment order, is the approval of the director required or the administrative authority is required? That is what I was looking into Rule 6.
No, it only says that, my lord, the selection committee will forward the list, and thereafter
Where?
Lord, that lordship will find, my lord, in direct recruitment, Rule 4, sub Rule 3 onward, page 118, 118.
Rule 3.
Rule 4, Lord, Rule 4.
Rule
3, page
shall
118.
after conducting the necessary combined list of pay in order and furnish to the appointing authority
Yes.
a copy of the combined merit list. So that is why I am saying it will be only to the appointing authority. Unlike if you see the 1977 rule made at that very point of time as regards the elementary education provincialization.
Correct.
If you see, then it has to be sent to the director of elementary education
For approval.
for approval. Once it is approved, then only the appointing authority can approve. Is there something to that effect? Otherwise, wouldn't it that be incorporating something which is not there in the rules?
But, my lord, so far as the selection is concerned, my lord, even if it is whole, my lord, prior to, my lord, SIU, then, my lord, the SIU, SLSC approval is necessary. The joint director on his own cannot move the SLSC without.
Where is it?
Well,
Show me that provision. Before holding a selection, SLSC approval is required. Where is
yes, it is required, my lord. SLSC is required.
Because if you see
Well,
Rule 6, not Rule 6, Rule 4. How direct you go? Before the end of the year, the appointing authority shall make an assessment regarding the existing vacancies and the likely number of vacancies to be filled by direct recruitment during the next 12 years and shall intimate the same to the selection committee.
Well,
Rule 4.1.
yes, my lord.
Together with the details about the reservation for so and so, the appointee shall advertise the vacancies, giving details about the reservation for the reserved categories and other necessary particulars by displaying the advertisement in the office board of the office of the appointing authority. In addition, the copies of the advertisement shall be sent to the following officers: Deputy so and so, all sub-engineers, all employment exchange.
My lord.
Here also, it doesn't mention that it has to be sent to the administrative department.
But, my lord, even otherwise also, being the, my lord, main authority here, concerned head of the department, my lord, without having their approval, my lord, any selection process cannot be initiated, my lord. Because ultimately, whatever proposal is will be mooted to the finance department for granting of that, my lord, budget and all. It will have to be through the administrative department, my lord. He may, my lord. It's not that, my lord, he cannot. Because after 2005, it is the director only, my lord, who can give the appointment.
Now, are these rules not statutory rules?
These are statutory rules.
If these statutory rules are straight up thing to be done in that manner, it has to be done in that manner. It does not give anything to the effect. The petitioners were very clever to get it done with the joint director of health,
Lordship.
but you can't help it.
But, my lord,
I understand your
Yes.
predicament. Yeah, it is very clear from here that how can they do so when the government has not been taken into confidence.
Yes, not taken into confidence.
So if the government has not been taken into confidence, the people who is going to give the money has not been taken into confidence, how it has been done so? And the answer to that is given by Mr. Nair to the effect that look here, why they are saying now that the government has not been taken into confidence. They have all along been giving the salary, everything has been done. All there was some inquiries were made, but nothing could be found out here. So this categorically shows that it was then the government thing was there, may not have been noted because it was not required as per the rules to note.
No, my lord, at least the select list will have to be forwarded. The government must know that these are the employees, my lord, under the department.
Show me where is it required that the select list requires to be forwarded, which is therefore the difference with the 77 rules of provincialization.
Lordship. But that part, in fact, I have also gone for the entire rules today, but it's not there. I've asked them, they said, my lord, that for SLEC, they will have to move. And for SLEC, the file will have to be mooted through the director, then the government to
Understood,
the
but
finance.
where is it? Is it on the basis of some executive instruction?
Yes, madam.
Where is it? You have to
That-
show us.
Yes.
Yes, under
Then I will place, madam.
161, it can be done so. By 161, you can do so, but where is it?
Lordship, I will place it, madam. Because that is the only issue. And on top, apart from that, Lordship, may kindly see Rule 5, page 1118, Constitution of Selection Committee, sub Rule 3. This also, my lord, they will, the joint director ought to have moved, my lord. Lordship will see sub Rule 3 at page 121, continuation of Rule 5.
Shall issue instructions.
The
on
administrative
following
department shall issue instructions on the following, namely, the minimum essential qualification for direct recruitment to the post or post and the age limit of the candidate, the minimum essential experience, if any, for the post or post, whether there will be written test, and if so, the name of the papers and the maximum marks for each paper, whether there will be typing test, and if so, the maximum so and so, whether there will be interview. Now, my lord, without this approval, my lord, he will have to move. He on his own cannot, my lord, bypass this.
But where is it mentioned that it is required for these things to be there, or that the select list, the selection committee
My lord.
shall only on the basis of this will select? Where is it mentioned?
Lordship will see, my lord. Constitution of Selection Committee,
Yes.
Rule 5.
Yes.
Rule 5, sub Rule 1, clauses, my lord, ABCD is the committee, my lord.
Yes. A, I have seen it. Will come under A.
Yes. Now, Lordship will see, my lord, page 121, Rule, sub Rule 2. It says, my lord, the appointing authority shall, in every case, before the commencement of the selection process, constitute and notify the selection committee as is applicable in his case, in the manner stated in the foregoing provision. Now, next step, my lord, he will have to do is, he will have to move the administrative department.
Where is it said the administrative department shall do it?
Yes,
It
the
is not
admin
mentioned that he
department-
has to approach the administrative authority. The
No,
administrative
wait,
authority,
yes,
unless by way of an executive instruction you link both, as what you are saying, that's a different aspect.
yes.
But if it is not done, then the administrative authority department had no quarrels with it till 2019 or 18, whatever may be.
Lordship.
And in the words of Mr. Nair, this is only to fulfill the 1 lakh appointments to be made. Isn't it, Mr. Nair?
Lordship. Otherwise, there's no other. But my lord, that may be stretching it a little bit far. This 1 lakh came recently. This is there from a repeated. But this is to make new appointments. Have vacancies.
But
How
my
do
lord,
you link it?
this is a procedure otherwise.
Understood, but how do you link it? You have to link it somehow.
My lord, my
But
lord.
that linking is missing.
No, that the administrative department shall issue instruction on the
Understood,
following.
but it is
Now,
not
my lord, that
administrative.
instruction will be
Just for
issued
example,
the moment joint director informs that, my lord, there he is going to hold a, fill up this particular post of grade 4. In
where
that
is it
case,
required that he has to inform the administrative department?
every step is not necessary that, my lord, it will be mentioned in the rules. It will automatically imply that he will have to move. Otherwise, my lord, how the director will know that, my lord, he is holding a selection, and how he will know that he will have to exercise his right, or this particular right under, my lord, sub Rule 3 of Rule 5. It is upon the joint director informed that if I am going to hold this, these are the vacancies,
But then how do you explain
Lordship,
that for the purpose of holding the selection
Lordship,
or the Joint Director of Health Service, as the case herein,
my lord.
will have to intimate the selection committee as regard that these are the number of vacancies and all. Why is it required to be mentioned that he has to inform? You could have very well mentioned the selection committee shall do that.
No, I'm not saying about that, my lord. Now, in order
So
to.
if it is not there in the rules, you have to supplement it by way of executive instructions. Where have you done that?
No, I'm not saying about that, my lord.
But can you
supposedly
say
he completes
on
my
the
lord,
ground that
procedure.
the administrative authority has not given these instructions, that this is illegal? But there is no mention that the approval of the administrative authority is
No,
required.
I'm not talking about the approval now. Lordship, may kindly see the subgroup
So if
3.
you are not talking on the approval, because you see, if you go by the 1977 rules also, another very relevant aspect is there.
My lord.
The rules categorically mention that the appointment shall be made taking into account the policies of the government prevalent at that point of time,
Lordship,
which is however not here.
Lordship.
Then how do you bring in the concept of ban?
No, if there is a ban, my lord, in that case, my lord, the joint director cannot, my lord. He cannot say that since it is not there in the rules, I will do whatever I want.
But you couldn't find out when the ban ended.
Yeah, that of course is there.
Just one factor. My friend may be proven. But today, when my lord is examining the matter, my lord will also examine the matter that after 2005 till 2018, we were being paid our salary. These posts were being utilized. And my lord, salaries, the budget is not done by the joint director. It is done in the directorate. They collect from every district, all the posts, the money required, then it is placed before the, my lord, the, what do you call that, the finance department. Now, if there was any anomaly, let's presume, my lord, there was an anomaly, it could have been got, but how these posts were filled up? No questions are any. So that shows.
So you
my
are
lord,
saying that there was a deemed approval.
there was an approval, my lord can even presume that there was a deemed approval. I say there was an approval. Otherwise, the salaries could not have been given, madam. Because at that transitional period, in 2005, there was verification at every level. I'll place that.
Well, let him place, my lord, in that case. Where is the verification at that
No,
point
no,
of
but
time?
Mr. Nair, as regards the other matters, except these where there is a particular thing, is the other matters you don't have a case.
My lord, I'll only request, my lord, for a fresh breath of life there, my lord, to remand the matters, those matters back.
No.
So that, my lord, we can have a, because these matters were done in a perfunctory manner.
Well, I
If
will-
my lord can remand those matters, my prayer, subject to what my lord would say, let them, because even in the but that other
No,
matter.
doesn't this court have to come to a finding that the appointment was legal?
No, my lord. The appointment was legal or illegal. That was directed to be done by the authorities. My lord, we have given our documents. Other than, my lord,
No, unless you come within the ambit of some natural justice business and all these things,
that's
those
what I-
are different aspects of the matter. But otherwise,
I'll not be
on
my lord. Only
the other
principle
ground,
of
why
natural
should I
justice.
look into it?
In that
Only on
regard,
the
my lord, I
principle
will
of
place
natural
some
justice.
judgment, my lord, in that regard, in case of the other, including these two cases too, Bongaigaon and Gwalpara and Dibrugarh too, I'd like to place some judgment, my lord, that I will place. They will have to show that, my lord, they have entered into the job, my lord, through a proper selection process. There are judgments to that effect. I am placing that.
No, there's no quarrel with that. That is what I am saying to him. As regards the other cases,
Even, my lord, for
is
ad
not
hoc
there.
appointment.
Unless he shows that on some grounds of natural justice, on technicalities,
Yes.
he can make out some case, then it is a case of remand. Otherwise, there is no case of remand. But
Only
these
on
two,
point of natural justice, my lord, in the other cases, I may have a plea before your lordship. Otherwise, I don't have anything.
you don't have it.
But here, my lord, in these two cases, select list is there, advertisement is there, appointment notice there. And now, my lord, will come to 1271 of Narayan Chandra Rao. Item number 3. 8220.
If I'll do that.
Item number 3. Right.
But Mr. Gogoi,
Yes.
this court is, however, not holding it. I will give you a chance as regards the termination, but because of the fact there are two things.
Well.
If I allow it, allow the petitions also, this court doesn't have the authority to say that the appointment was legal.
Lordship.
But on the fact that you have not looked into those parameters which are required to be looked into.
But-
The decision is perverse, thereby giving you liberty to take some action as deemed fit.
In respect of Gwalpara and Dibrugarh.
Absolutely. But because as of now also you are not certain.
Well, the written instruction is on the way.
No,
but I
as
will
of
just
now
say-
also, till after so much of these matters are going on, people are laughing at me, taking into account that these matters take such a long time.
No, madam.
And this is the state
No,
of
no.
affairs.
Lordship is delving into the issue, man.
Huh?
Lordship has been delving into the issue. So-
Delving, but my delving out there has to be limited to a particular thing. So in that case, you have to take a fresh call into the matter for whatever reason, because your reasons by which you have done
Yes, yes.
was a ban for which you couldn't show that there was a
No, it
ban
is
for which period, because there has been further appointments.
My lord.
Like if I remember for the Operation Blackboard, there was a specific WT message issued to the effect that this ban is lifted the day on which the sanction was granted for the 7076 people. That has been done so. So whether something to the effect happened, unless you show it,
Lord.
that yes, the ban continued when it was lifted.
Yes.
So that is one. The second is as regards the director's approval. The director's approval is not there. I couldn't find out there in the rules on the basis of which you are saying that there is a question of director. So this termination, if those are on reasons which are not relevant, then obviously the termination has to go.
My lord.
However, liberty is always upon you to come up with no res judicator in respect to other aspects of the matter. But the other matters,
Yes, including
except
district
natural justice.
Well, towards the judgment, my lord, may I place it and that part can be completed. So
Which
far as
one?
other cases are concerned. So
What
that-
are the judgments? Tell me.
Otherwise, my lord, the common judgment, my lord, I will rely upon my lord white token thing. White token thing, my lord. And next is the state of Bihar versus Devendra Sharma, 2020-15 SCC. There, my lord, it has been stated that, my lord, if the appointments are made by a particular authority without having the concurrence or approval from the higher authority, in that case, my lord, the entire selection is a nullity. Even in my lord white token, I will place the paragraph.
But you
Same
have to
has been
show,
re-
but if you go into that, you have to show whether it is the AI is required.
Authority, yes.
If it is not there, how do you apply the judgment?
But other aspect of
No, you can very well rely upon the judgment of Aligarh Muslim University to the effect that even if whatever may be done, if the principles of natural justice,
that my lord has
if
been
it-
discussed in my lord this my lord Devendra Sharma, state of Bihar, Muslim Aligarh University. has been discussed.
so that is to the
And it relates to the my lord employees, my lord, same scam, my lord, like this, my lord, in Bihar health department. There, my lord, inquiry was conducted. Finally, it was found that, my lord, they are all illegal appointment with fake appointment letter. May I, my lord? Lordship, may kindly have a look at this, my lord, 2000.
okay, let me see the other matters now.
Lordship.
Till your instructions are received. But this, I made up my made it clear to you. You are to show me this, and otherwise the consequences befall upon you in this manner.
Lord,
Yes, you were showing some case
My lord, 1271,
1271.
Lordship. a page, number 3, item number 3. Page 127. Narayan Chandra Rao.
5013 and 8220 are Dibrugarh and Gwalpara.
No, Your Lordship. 5013 Arunima Kupuk is from Sagar.
One.
You have a good case where?
Gwalpara.
and Dibrugarh.
और किस तरह था?
Dibrugarh, it is my lord Joyanta Hadari.
Sibsagar and Gwalpara, 3 cases.
Which are the two matters?
Gwalpara is 8220-2019. Then, my lord,
एक कागज
Sibsagar
এখন
is
লেখক তুমি Gwalpara.
And item
আমার
number
কাগজ পিতা এটা মাই জোকস।
3 and item number
This is Gwalpara. Then 8220.
then put 1931.
1931, that is Dibrugarh, man. Dibrugarh.
Oh, you have given me some note, no?
Yes, your lordship has, on last.
5013 is
Purnima Gogoi.
Onima Gogoi is which?
This is Sipsagar.
Sipsagar, you have a good case.
Those cases,
What happened was,
contractual employees, man.
Oh.
Huh?
They were regularized by
Yes, yes.
somebody.
Yes,
That one.
yeah, but only in
Sipsagar.
Gwalpara and
No, your
Dibrugarh,
lordship, in that
advertisement
case,
is there.
no, Purnima to
No, then I will put another question. I've thought about it. What about Narayan Chandra Rabha?
Narayan Chandra Rava is Golpara. man.
There you have a case.
That is where man, everything is there. Appointment order, select list, acquaintance role.
And Ajoy Kumar Singh is
Tinsukia.
there you know case.
No case. no.
Dimple,
Temple, Borpeta.
Borpeta.
no case.
Pranjal is Kamrup.
Anjul, no case.
No advertisement.
Huh?
No advertisement.
No.
Abdul Rabia, no
Morigaon.
advertisement. Morigaon.
Huh?
Morigaon.
Abdul Rabia is
Morigaon.
no case. Vishwajit Hendik,
Not Lucky.
No, no case.
Not
madam.
lucky.
No advertisement. madam.
Not Lucky.
no case. Why all these problems happen at North Lakhimpur and Dhemaji?
Yeah, including Sipsagar.
Om Bahadur,
Om Bahadur Chetri,
Tinsukia.
Tinsukia, man.
Tinsukia, no case.
No case. man.
Make your submission.
No advertisement, nothing. man.
Purvajit Das, it's
Then-
Purvajit Das, Morigaon.
Purvajit Das,
Borpeta.
Morigaon.
huh?
Morigaon.
Morigaon, no case.
No.
Yeah, his services were placed at the disposal of Joint Director of Health Service, North Lakhimpur.
Thereafter he was transferred.
Transferred. man.
Thereafter, he was transferred to Borpeta.
Sorry, Borpeta. It's Borpeta.
No, don't make a mistake.
No, it's
I'm about
Borpeta,
to
madam.
dictate the judgment in your presence.
Yes, your lordship.
Borpeta.
Then Navajit Pathak.
Morigaon. man.
It's Morigaon, your lordship.
Okay. Jayanto Hazarika,
Dibrugarh. man.
you have a case.
I have a case.
Huh?
Yes, sir.
Pradeep Borgohain,
Sipsagar.
huh?
Sipsagar.
Case? No case.
No case. No case. Contractual. man.
Even this, they require the contractual employees in the department.
Now let us go into the question of natural justice. Yes, Mr. Nair.
Man, he'll like it. Now I don't know. Malad will have Ajay Singh, Malad. Malad, my friend, he's very complete. He's prepared.
Your lordship will start from Arunima Gogoi, your lordship.
Yeah, got it. Ornima. What is your point on natural justice?
Your lordship, in case of Arunima Gogoi, there was a land donated by the father-in-law of this lady.
Only one petitioner?
Yes, your lordship. This is
Huh?
from Sipsagar. Yes, your lordship. Only one.
Okay,
Therefore, I filed it separately because the cause of action is a bit separate, your lordship.
okay.
In
Then-
in that case, your lordship, a land was donated by the father-in-law of the lady, and a health center was constructed there. And accordingly, on the basis of that donation, she was appointed on a contractual basis, and she continued there, your lordship, thereafter. But one,
No. Tell me, whether out here
yes,
in Assam,
Yes.
you had a scheme which is similar to which was there in Nagaland, that whenever you give a land, you are given an appointment. You don't have that. So there is no nothing to.
But your lordship, I just want to show few documents that there were communications between the department. In
Hmm?
fact, there were communications between the department that something should be done. If I may draw your lordship's kind
No,
attention,
unless there is a scheme to that effect, how can you give the
therefore,
Yeah.
I just want to say your lordship, the deputy commissioner was in fact has communicated with the deputy secretary, the joint director of health service and the director of health service.
but where is your vested right for that
Your
or
lordship,
any form of right?
the right accused in the form that your lordship, that I have applied for it and
No,
accordingly.
no,
I was-
first of all, you have applied, you have got a contractual job, whatever may be. Till their contractual job, it is okay.
Fine, your lordship.
But
Thereafter, I was regularized, your lordship.
regularization has been done without any basis by the
Yes, your
joint
lordship, but
director or
there are
whoever
some
it is.
communication. At least your lordship, this is a poor lady, your lordship. As on date, they have nothing. So later continue in the contractual basis, your lordship. The department requires. It's an admitted fact, your lordship. And she has nobody to
So
look
this is
after.
on sympathy, not natural justice.
There are two issues, your lordship. Why I'm saying so? My land has been acquired. At that moment.
Land has not been acquired, it has been
Sorry, I'm
donated.
sorry. It's been gifted, your lordship. Now,
Then-
on that basis, plea was made. A communication is there, your lordship. If I may draw your lordship's kind attention to,
Did you make it one of the condition precedent that I am going to donate this land for which you have to give me a job?
I could not lay down anything on this, on that document.
So
your
we are
lordship.
to only on presumption that the land was given, so this is a.
In fact, there are documents, your lordship. If I may show your lordship the document.
Because you see, in all other states, they have this scheme,
Right, your lordship.
which is not here.
Yes, your
So
lordship.
we can apply that.
Your lordship.
So it is only on the basis of contractual thing you have been. So your basic argument out here in Onima Gogoi is to the effect that let her continue in as a contractual till that.
Page
Nothing,
260.
see, you are not emphasizing much on the regularization.
Yes, your lordship. Yes. 260, your lordship. If your lordship kindly looks at page 260 of Orunima Gogoi. 260, annexure 23.
Yes,
From director of
enclosed
health
here with
services-
a photocopy of the government letter along with all enclosures in respect of Srimati Anuimago for taking necessary action.
Therefore, the earlier to this now, this was from the government, your lordship, Malika Methi, deputy secretary.
And
to
the
the
total
government of
number of so under the
259.
Chiptaka 302, out of 302, number of posts in grade 4, number of vacant posts is 34. Then, so you can be accommodated there.
At least on contractual, your lordship. No, this is the total
No,
vacancy.
here, where is your natural justice? No natural justice.
Your lordship, why I'm saying natural.
On
justice-
sympathy.
No, why I'm saying natural justice, your lordship,
Hmm.
while I was terminated, they say me that I was illegally appointed. But the fact on the basis on which I was appointed initially on a contractual basis was because of this fact that a loan.
Where is it? In your appointment order, it is mentioned.
No, your lordship.
Then-
It's not there.
It is a developing of the case because its matter has come to Mr. R.
Lordship, you
Sinha.
see para number 2 of the writ petition, man. This is not his pleaded case. Para 2, page 12. Contrary statement has been made.
Contrary statement. Grade 4 staff in the so under the NZN was under employment, unemployed and as such in search of jobs. The petitioner came across an advertisement published wherein application was invited in the office of PITA.
So now
Applied
this
for
is
the
his case.
same day, thereafter participated in the selection and finally the petitioner was selected against the various advertised posts. in the state court. Joined the services in terms with her appointment and since then the petitioner has been looking to the entire. Okay.
Your lordship, in para 3, I had stated it categorically that I was appointed on casual.
Where? However, she was appointed on casual basis.
Yes, your lordship.
Where is the contractual? It's not on contractual. I hope there's a difference between casual, contractual, contingency.
Yes, your lordship.
In long and short, Mr. Raskrishna, this is a case of sympathy. we will look into that sympathy.
Lordship, page two.
I put that sympathy in a different pedestal.
In fact, your lordship will
Next.
kindly
Okay, I will put a question to you at a later stage. After some time, see, this is a sympathy. Next, which one you want to argue? Gwalpara, you have a case, na? Gwalpara, you have a case.
Yeah, everything is there.
Let us look into then Ajoy.
Ajay Kumar Singh.
Gwalpara. Okay. Okay, Ajoy Kumar Singh, let us look into that. And three others. Reduction 8423.
Your lordship, there are 4 petitioners in this case.
Hmm.
Yes, my lord, I make more submission
He'll get your chance.
after that instruction.
Let me complete with this natural justice business.
Your lordship.
Because one thing, you see, which I will just think about, a person having worked for so many years. Yes, it was an illegal appointment. This court is, however, not going to give direction for regularization on that.
Right.
But having worked out there, wouldn't they have a legitimate expectation for consideration of their case?
That part has been dealt with in Umadevi matter. That
Huh?
in Umadevi, that part has been dealt with, my lord. It is there in Devendra Sharma's case, my lord.
What does it
Specifically.
say?
My lord, they cannot, my lord, in such, my lord, public appointment, my lord, without following Article 14 and 16 if somebody's appointment, this legitimate expectation business will not come. In fact, my lord, in Mamta Mohanty's case, Honorable Court has held that part also, my lord, I will place. Let him complete, my lord, I will place my part. Is there already?
No. I'm saying, I'm telling you, no, Mr. Gogoi, Uma Devi takes into aspect primarily two questions. One is whether 226 power is there for the purpose of regularization. And secondly, can the court under 226, on the basis of legitimate expectation, direct them for consideration? I'm not on that.
No.
My thing is, having worked for such a long time, whether they will have a legitimate expectation that the government can take a decision to regularize their services,
Right.
taking into account that they have worked for all these years. There's a difference in both. One is a legitimate expectation for consideration for their prayer for not regularizing, for continuing their service. That is one reason. I'm not on that. I'm on the basis that as the government has been taking into account, let us see in the teacher's case, you have found out right, left and center, there are illegal appointments, irregular. In fact, if you see the case of the state of the J&K versus District Court of Bandipora, Justice Chandrasud has been very categorical in explaining what is regularization. It says an illegal appointment cannot be regularized.
Yeah.
So the question of regularizing does not arise. However, the state government left, right and center has been doing so, which have been recently done in that 7/10/2021-20 in regularizing those irregular employments
BTC
of the
cases.
teachers and now giving them the tutor or teachers to that effect as new appointments.
As per the
Fresh.
Provincialization Act.
Not provincial. Provincialization Act does not say anything to that effect. You have taken a decision that initially it was there that there was a direction passed by this court in 2010. They look here, these are all illegal appointments, form a screening committee and find out. Pursuant to that, you have a screening committee of from 5 or 6 committees to that effect. This committee gives recommendation in respect to 4 categories of teachers.
Right.
One is a category of teachers who are recommended and have been working. Total is 175. Second is the category of teachers who are recommended but not working. Third is the category of teachers who are not recommended but working. That is 8470. And the fourth is some 2000 something is those not working and not recommended. So as regards one, we have done it because they were regularly recommended everything.
Well,
Two, the question did not arise because they have already left the job. Three was the question. You were supposed to issue show cause notice. The department had thought about it. Then the Minister of Education intervened out there that let us do one thing. We take up another route. So what they did, that those people who have received some sort of a salary till 2007 and have the qualification, they were given a fresh appointment foregoing all other claims which they had as teacher. As regards the other aspect, the second who did not have the qualification till 2011, they have been given but received salary till 2007, have been given for the purpose of tutor. And the others you did not do it. Now, if that is a yardstick which is being taken by the government, I'm not that this court is going to impose upon the government. But whether those people concerned can also take note of that as the government have done so, can the government not consider our case also?
well, these are one thing, well, I like to point out. Not only they are held to be illegal, but they are termed as fake appointment. They are termed as fake appointment. And regarding the government is concerned, so far as the health department is concerned, Melo, there is no such possibility that Melo, they will be taken back. Otherwise, through a policy that I can.
Government has not taken it. Government, that is why when the cabinet is taken up this decision on 710 for those illegal, irregular teachers. Illegal means what? A teacher who have been appointed, divorce, Article 14.
Article 14, yeah.
That is why the Supreme Court in that judgment has categorically differentiated what is a illegal, what is a irregular. And saying that a person in the garb of regularization, you cannot regularize an illegal teacher.
Well,
but however, it is being done so. So, on the basis of that, couldn't they request or the government in its wisdom take a decision that, okay, these people have worked out there for such a long time. There are vacant posts out there. To that effect, to do something to that effect. I'm not saying that this court is going to direct it. That is another aspect of the matter which can be looked into. But this court is not going to direct. This court at best can only request upon them submitting a representation. But the government in its own wisdom may take such decision as deemed proper. That can be done at best.
Yes, sir. Yes.
As I had given, if you see, remember, in that matter pertaining to the nurses, I have not given any direction.
Yes.
I had made a specific request for the chief secretary as well as the government. They can be considered if they can be done so, if they can do so as per their wisdom.
Yes, sir.
That is the only thing which I can see for your case. Otherwise,
Beyond
you
this,
don't.
nothing.
Huh?
As an officer, not as a petitioner's counsel. As an officer of this court, my lord, beyond that, my lord may not like to do under 226. That, my lord, let them do.
I'm not going to, Mr. Gugoi, kindly don't think. This court, first of all, does not pass any orders for consideration unless I find any right. But having worked for all these years, they may have some expectation, may not be a legitimate or whatever may be, but wouldn't that the court should, the government can consider that? May not consider it a different thing.
2 paragraphs of Uma Devi, my lord, regarding legitimate expectation in these sort of cases. May I read out, my lord? May I like to take a break? May I place that, my lord? Para 21. This is, my lord, 2020 15 SCC, page 466. Para 21. in Umadevi 3, the argument that the employees have legitimate expectation was negated when this court held as under. The doctrine can be invoked if the decisions of the administrative authority affect the person by depriving him of some benefit or advantage, which either one, he had in the past been permitted by the decision maker to enjoy and which he can legitimately expect to be permitted to continue to do until there has been communicated to him some rational ground for withdrawing it on which he has been given an opportunity to comment, or he has received assurance from the decision maker that they will not be withdrawn without giving him first an opportunity of advancing reasons for contending that they should not be withdrawn. There is no case that any assurance was given by the government or the department concerned while making the appointment on daily wages that the status conferred on him will not be withdrawn until some rational reason come into existence for withdrawing it. The very engagement was against the constitutional scheme, though the commissioner of the commercial tax department sought to get the appointments made permanent. There is no case that at the time of appointment any promise was held out. No such promise could also have been held out in view of the circulars and directives issued by the government after Dharwad decision. Though there is a case that the state had made regularizations in past of similar situated employees, the fact remains that such regulations were done only pursuant to judicial directions, either of the administrative tribunal or of the High Court, and in some cases by this court. When a person enters a temporary employment or gets engagement on a contractual or casual worker, and the engagement is not based on a proper selection as recognized by the relevant rules of procedure, he is aware of the consequence of the appointment being temporary, casual, or contractual in nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post could be made only by following a proper procedure for selection, and in cases concerned in consultation with the Assam Public Service with the Public Service Commission. Therefore, the theory of legitimate expectation cannot be successfully advanced by temporary, contractual, or casual employees.
Therefore, Mr. Gogoi, this court is not unaware of these things.
Yes,
So that is why I say to you, Umadevi decides two aspects.
Sure.
One is this court under 226 cannot direct regulate.
Well.
Because it is absolutely within the domain of the executive to do.
Except that exception in para 53 one-time measure or given.
53 is only those who have been there should not be disturbed unless they were there on the basis of judicial.
No, it says the one-time measure is to be carried out by each state government for regularizing the irregular appointees, be it contractual or casual, as a one-time measure. Thereafter, there should not be any such engagement. Every state government was supposed to do that. We have done it in 2013.
Okay. That is the
One
53 is a one-time measure which
One-time
the court
measure,
has done. That is a different. I am not on that.
Well.
And that power has been exercised under 140.
Yes. Yes.
Now, I am not on that. I am only on the question.
Well,
As you have read those two paragraphs, it shows that a person's appointment which is there was casual, temporary, and so on. They don't have a legitimate expectation that they should be considered for regularization or being confirmed. That is what has been mentioned. In fact, recently in the dissenting opinion of Justice Murari, he has further developed on the concept of legitimate expectation
well,
in a recent judgment which was delivered on 15th of May. The question arose as regards, in fact, what has been seen out there is a legitimate expectation in the tune of a promissory assault.
Sure.
That a person, if he changes his views, give him an appointment or doing something and there is an endorsement being given to him that look here, we are going to confirm you something. Just for example, let us just take his case, wherein he says this particular land was being gifted. And at the time of gifting of the land, there was the authority concerned said that after some time we are going to regularize it, which is obviously not his case, but then also if there was something to the effect, then the Supreme Court holds that yes, he may have a legitimate expectation for that, because you are giving him a service for. But merely if there is no assurance being given to them by the decision maker, then you can't incorporate the principle of legitimate expectation. But my question is, let us assume they were given permanent employment, whatever may be, these are being struck off. This court wouldn't touch on that. But can't they be taken and put out there as a casual employee and then continued something? I'm not on a direction to the effect that they should be doing it.
Well,
But can't the government take a decision on that, not on basis of regularity? Because therefore, I'm saying
Yeah.
the concept of regularization, if you see the judgment, then
My lord, if the government desires, we are not, my lord, these category of people are not so much different than the casual employees and work charge employees working. Upendas's judgment, the spirit thereof, can still be applied here. Subject to, my lord, being said that continuation till their retirement without regulation with that protections.
no, I thought that also, Mr. Nair, but the problem arises there is Upenda says those people who have been appointed as casual labor or all these things. But there has to be an appointment. If the appointment is fake, then what happens?
No,
That means
even
non-sanctioned
in a
post.
casual
in
Mazdoor,
non-sanctioned post,
No,
there
no.
they are getting the salary till their termination.
my lord,
No, that they won't get it, but now
No, no,
that is
no.
why I'm saying.
no, my lord, in a casual employment scenario, my lord, there is no appointment. It's just an engagement.
Yes, take this. Second video. You read this judgment on paragraph number 11, paragraph number 26, 25 or 20. Paragraph 11 deals with
Well, yes, sir.
paragraph 11 deals with what is Uma Devi.
Yes.
If you read it,
The decision in Umadevi 3 dealt firstly with the right claimed by temporary employees to be regularized in service on the basis of long continuation, legitimate expectation, employment under the state, and the directive principle. The second salient question which the constitution bench was called upon to answer was whether court would be justified in issuing directions for regularization based on such features such as equality and long spell of service. On both counts, the constitution bench held against the temporary employees. However, Umadevi is not an authority for the proposition that the executive or the legislature cannot frame a scheme for regularization. Umadevi 3 does not denude the state or its instrumentalities from framing a scheme for regularization. In para 53 of the decision, this court held as under.
now kindly come to 26.
the principle will have to be formulated bearing in mind the position set out in the above judgment. Regularization is not a source of recruitment, nor it is intended to confer permanency upon appointments which have been made without following the due process and which is under by Article 14 and 16 of the Constitution. Essentially, a scheme for regularization, in order to be held to be legally valid, must be one which is aimed at validating certain irregular appointments which may have come to be made in genuine and legitimate administrative exigencies. In all such cases, it may be left open to the court to lift the veil to inquire whether the scheme is aimed at achieving the above objective and is a genuine attempt at validating the irregular appointment. The state and its instrumentalities cannot be permitted to use this window to validate illegal appointment. The second rider which must necessarily be placed is that the principle as formulated above is not meant to create or invest in a temporary or an ad hoc employee the right to seek a writ commanding the state to frame a scheme for regularization. Otherwise, this should simply reinvigorate a class of claims which has been shut out permanently by Umadevi. Ultimately, it would have to be left to the state and its instrumentalities to consider whether the circumstances warrant such a scheme being formulated. The formulation of such a scheme cannot be accorded the status of an enforceable right. It would perhaps be prudent to leave it to a claimant to establish whether he or she falls within the expectations carved out in para 53 and falls within the ambit of a scheme that may be formulated by the state. Subject to the riders referred to above, a scheme of regularization could fall within the permissible limit of Umadevi and be upheld. Finally, it says about the irregular appointment as defined in my lord Umadevi. In the present case, my lord, all the terminated employees have been held to be fake appointed. They claim that they have been appointed, whereas there is no such election been held, no record is there. There is no even single appointment letter in our record.
No, one very relevant aspect out there in that paragraph itself,
My lord,
wherein the Supreme Court said
Lord,
that regularization is not a concept of
yes, my lord.
recruitment,
Yes.
it's a mode of recruitment.
Regularization is not a source of recruitment, nor it is intended to confer permanency upon appointments which have been made without following the due process envisaged by Article 14 and 16 of the Constitution.
Therefore, while I was taking up that other matter pertaining to old pension, new pension, and as I was taking the drop teachers aspect,
Lord,
if you see all the appointments of drop teachers, you will find out there that these people were regularized.
Lord,
Now, if you see the rules of 77,
my lord.
the concept of regularization is not there.
Yes.
The mode of recruitment is either by way of promotion or direct recruitment.
My lord,
So there has to be an appointment.
my lord.
The regularization is only by an idea
Lord.
on the basis of which the recruitment process is brought to its logical end.
My lord.
So therefore, it is now if you do this, look into this and take into account what has been done in respect to those irregular teachers.
My lord.
These are people are not given any benefit earlier.
My lord.
The earlier benefit has not been given only for the purpose. The moment the earlier benefit or earlier salaries are being given,
Validated
it
the
would
entire-
be regularizing
Yes,
and
sir.
thereby giving a continuous benefit of what was there earlier.
Right.
Therefore, all these appointment orders which are made on 31/1/2021
Right.
are specifically saying that you are not going to get any benefit of earlier things. You have to give or waive off. And therefore, this benefit is being given as a form of a regularization by giving them fresh appointments.
It will be prospective.
And this is absolutely within the wisdom of the state to do so.
Unless, my lord, same is put to challenge by some third party.
Somebody may very well challenge everything. Why not? Till the matter goes to the Supreme Court, everybody will challenge. But there are many cases which are not challenged
Yes,
also. And as such has attained finality.
And Upendas can be brought in.
Huh?
In Upendas's spirit, can be brought in, my lord, by the state. They did not regularize that benefit
No.
that was given. That is also given to these people.
Upendas, my lord, it is very clear, my
they
lord.
sustain. 20
Only,
years old now, my lord.
No,
Only
but
those
Upendas
persons-
is a case where those people were appointed on regular basis. They were appointed as casual or master role or
They were all, my
contractual
lord, picked up.
basis.
in non-sanctioned post, my lord, it is very
No,
clear.
they were all appointed and they were claiming regularization.
Lordship.
Then the High Court said that
No
nothing
regulation.
to it. But we are not on that. We are only on a case where you have been terminated.
Fine. I've been terminated. And my lord saying
Then
that
how can I give you the minimum of scale of pay?
even if a casual employee comes up for a regularization, the plea that will be taken from the other side, relying on Uma Devi would be, my lord, that you don't have an appointment, you are not against a sanctioned post. So you are not entitled to regularization. Now, if my lord interpolates that to our case, here, say my lord, that thing is bad. That initial appointment is bad, we have to be deemed.
No,
to be
Mr.
a
Nair,
casual.
there is a big problem out there. You see, Upenda springs from the dictum of the Supreme Court in Jagjit Singh.
Lordship.
Jagjit Singh says that those persons who are in casual or temporary basis out there,
Should be given.
they may not be entitled to the pay scale which a regular person is getting, but however, they are at least entitled to the minimum of the pay scale.
Lordship.
It is on the basis of that this has been done.
Done.
But we are in a situation where your appointments are being terminated.
My lord, terminated on the ground that it was not done by following the procedure prescribed.
Absolutely.
So, my lord, even a casual Muslim, my lord, just the final result, if they want, my lord, final thing that they can think of, my lord, is that both would come to a stage, my lord, when both are safe. Because our initial appointments till 2020 were regular. My lord, for the purpose, my lord, for the purpose of payment of salaries, everything. After that, it was found to be illegal. Let me see, it was found to be illegal. Or illegal means, my lord, it was not as per the procedure prescribed. They cannot call it illegal, it was not as per the procedure prescribed. Now, both a casual Muslim, because I'm also working there, I'll not be entitled to the salaries, perks, everything. But my lord, the minimum following Jagjit Singh and those casual Muslims, they can, if they, my lord's that observation, if they finally say, okay, final, we will do that. Either they can put us prospectively in that post, as they have done for the teacher, or my lord, even they can do it by applying the spirit. I'm
No,
not saying
those teachers, it is a case where it is absolutely within the wisdom of the state.
the state, my lord, I'm saying they can do both. my lord.
This court can't direct anything to that effect.
My lord, if the state feels that giving us the salaries to that extent would be burdensome for them, they can even think of, my lord, a scheme in lines of Upendas for these category of people. That way, my lord, both we sustain. We have been working with them for that long. And grateful, my lord, in wards we were working. Doing the menial job that is possible. It's not that we were working in offices. They can, my lord, accommodate to us. I'm sure, my lord, 226, my lord, may not be pleased to direct in that case. But if an observation is made and they take it up in the manner they have taken up with regard to the teachers and all, same thing.
But no pension gratuity.
Nothing, madam. Fine, madam. Whatever they have, they'll get up. Other two cases, I'll try to satisfy your lordship, that they should be continued. Here, my lord, these cases, I'll leave it here with that observation. More than that, maybe I will not be possible.
Yes.
That part, my lord, leave it to lord. That will be an observation subject to day submit representation to put out.
No, no, that clear.
Fine, madam, we'll do that.
But so far as the termination part is concerned, my lord,
That would be, my
That
lord,
I would not touch.
my lord would say, my lord, that would be subject to the decisions that would be taken. By them.
no. There,
The decisions, because we'll have to be brought back, my lord, that this termination, my lord will only make an observation. My lord will not interfere with the termination. But tomorrow, they, my lord, take a policy that we will be brought back. Then this termination will not come in the way. That much, my lord, may observe. Otherwise, they'll take, you have been terminated, so there is nothing to do. So that impression should not go, my lord.
I think they will know. Not necessary.
of course, my lord, if they take a policy,
Not we have been only one. I have been only 1.5 years from there. I know. Not necessary to put that.
I got it.
Yes, tell me, how do you take care of the other two cases?
Other two cases, my lord, can be on some other day. I'm waiting for the instruction. They are saying that they are furnishing it. Let it be some other day. Rest, my lord, because that will be, my lord, the argument will be different, man, from that time. Because
The argument is this, I'm
the
telling
only
you.
thing that, my lord, if I can place the SLEC notification, where it is, if it is clearly stated that, my lord, they will have.
If there is any executive instructions
fine.
which connect, it is a different thing.
Yes.
Otherwise, the reason which we have taken, because you see, that is why there is a great difference with the provincialization rules of 77 with these.
Yes, yes,
Provincialization rule says with the government policies. There's nothing mentioned of.
nothing.
But yes, if there is a ban out there, they can't. But you can't show when the ban was lifted. And that too, he comes up with those RTI documents where Joint Director of Health Service categorically stated, look here, we were never informed about any ban.
And my lord, he says these appointments are genuine. I have also brought in record.
And what steps have you taken against the Joint Director of Health Service?
By now, my lord, in fact, my lord,
Unless he
so
has
far as the
died.
no, so
Criminal
far as the-
case, why not? You have registered against him. Because if
the
that,
police case has been registered, my lord, not in the case of for this particular joint director, but against the director and other employees of the directorate, my lord. It has been registered, my lord.
no, the person who has given the appointment, why haven't you done that?
My lord, this particular issue
Why
has
haven't
come
you
up in
stopped?
the
Why
affidavit in
haven't
reply.
you initiated proceedings? Now, obviously, you can't do as per now. If he has retired,
retired.
you can't do
4 years back.
any disciplinary action. But
Not for 2005.
No, it is 4 years ago.
so now you can't do that. But otherwise, criminal case can very well happen.
Lord.
Why that has not been done?
But that part,
Now putting the blame upon this petitioner.
otherwise, my lord, case has been registered against joint directors as well as the lead and director in 2005, my lord, Vibha Uzai. Against him, my lord, case is pending, including, my lord, some.
Is it something like a defamation case?
No, no,
Person
no.
files a suit.
Somewhere
I
arrested
filed
him,
a
my lord.
100 crore suit for that,
My lord,
only for the purpose of showing it to the people out there. Yes. See, I have been defamed. I filed 100.
So, my lord, after filing that, my lord, it's up to the investigating authority to.
Understood. You know, it is.
I'll test this one. This argument. 2005 criminal cases filed. That means these appointments were illegal.
No, no,
It
not
was known to the-
2005.
it was
Not
known to the-
2005.
It was known to the
Subsequently, when it came to light, my lord, after the inquiry was held, screening committee was constituted, the
2005
CM vigilance was there. That I'm saying, my lord. not this. Because,
CM
my
No,
lord,
no,
vigilance was
let they can very well do it. Now also they have come to know they can very well do
Yes.
it. There is no limitation if it is more than 7
But-
years out there.
but
No,
my-
no limitation
But
for
my
that.
case is, my lord, that you have not done, you were not required to do anything because these appointments were in terms of your own procedures. Otherwise, the treasury officer would never have honored these. It could not have been.
but
And
there is
the
no
budget
dispute.
was coming from the
Now, what have you done with the treasury officer? What have you done with the budget?
budget was being
finance
prepared from the department.
Have you done it with the finance?
Finance is not a party here in my
Not
lord.
here.
My lord.
Criminal case. Because they have done it. Normally, finance looks into everything.
Everything.
My lord.
The SIU, more particularly in your particular letter or clarification be given why the SIU is required.
Yes.
In the last paragraph, you have categorically mentioned out there that unless the SIU approval is not there, they won't get the budget and salary to the
But
defense.
there's a scam,
That's
my
what I
lord.
wanted to.
That's why, my lord, there's a scam, my lord.
So
If
why
this
haven't
scam, my
you
lord,
included the
it can be
finance?
detected at a very threshold. There won't be any scam, my lord. So this is a scam, my lord. When it came to light, everything, my lord, pursuant to that, my lord, the
Even
FIR was
the-
lost.
Even the deputy commissioner should be brought in then, my lord. Because the July
The lordship's direct, my lord,
2005
it will be done, my
notification says,
If lordship gives any observation in these two cases, that is Gwalpara and Dibrugarh, of course,
why? Because there is nothing
and-
now they want to
that
create
is
something.
not the pleaded case, my lord.
Yes, it's their document, it's their own document, my lord.
So
07
regarding
2005.
FIR and all, my
Although recently the Supreme Court said
lord.
that in a 437 matter also, the High Court has the power under 226
Right.
to give directions for departmental inquiry against it.
Yes, sir.
But the Supreme Court has also said normally it should not be done.
my lord.
Why should they do that?
Not- Because, my lord, it's their own procedure.
Tomorrow you
In
will
that it
go-
was done in that manner.
Tomorrow that person will go and file an appeal saying that, look here, I have not been heard and now these people have, this court has given this direction that a departmental proceeding or a criminal action should
Why
be
should be
taken.
done?
And
Yes.
because of them, I'm put to arrest or something to that effect. Look at me, I'm 85 years old.
And that's why I'm saying, my lord, finance is not a party, my lord. If they are one.
No, no,
person,
no,
only-
nothing to do with the finance. I'm saying,
The officers.
you see, your basic case is the finance approval. SIU approval is not there.
Not.
Now, if SIU's approval was required,
Well.
why did the FIU give that approval for getting the salary?
Otherwise,
My lord,
without
SIU
SIU
approval is
salary
not
could not
there
have
in
been.
the case. Somehow it was managed, my lord. How it was
Are they?
managed, my lord.
This is, my lord, I don't
No,
know.
understood. It is, let us assume it is managed.
Yes, but
But
that's
now it has come to light.
Yes.
Now have you been taking any action on that?
the health department, my lord, cannot take action.
Not health department. Isn't
know.
it a scam where the overall it is under the chief minister's vigilance cell, the BIU, all these things?
Lord.
Then why not? They don't have the authority. If you file an FIR, that health department files an FIR.
Yes.
And the health department, the police out there investigate, or if it is done under the CID, the CID investigate those finance people.
Yes.
They can.
Of course.
So why do you bring in that I am the health department and can't do it? Chalo, we will have it on some other day then.
Lordship.
This aspect I've made it clear with
Lordship.
this. I'll have a look at what is given out there, those other two cases. But these two cases, you see, that two reasons why you have in the
Yeah.
screening committee is on the basis of the ban as well as the
Directors of
No
Directly.
approval of the higher.
directors. This, I'm telling you, this court finds it extraneous. And the extraneous, this I have to set aside. However, liberty will be given to you. Thank you. That is the only thing I can.
Yes.
My lord will have it on a.
I'll have it now. When? Not far off.
No,
People
my
will
lord,
laugh.
Tuesday, my lord.
These matters
Coming
are
Tuesday.
giving
Provided my lord's board is permitting.
and
Yeah.
such big files.
No, Tuesday or Thursday, whenever it's called. Tuesday.
On Tuesday, man. I will
Tuesday,
get-
I've got a lot of matters on the 23rd. Both matters, you know. And they will.
Any day, my lord, convenient. man.
Hmm?
Any day convenient to discuss.
My lord,
man.
30th or first, 30th, my lord, the other day, one case. My lord wanted to fix it on 30th. 30th, my lord, okay. 30th, Friday, oh, Friday. No, me.
No, not so far off. Okay, let me try on 25th. 25th.
25th, man. Fine, no, 25th.
Heard Mr. UK Nair, the Learned Senior Counsel, assisted by Mr. R. Sinha. Mr. B. Gogoi appears on behalf of the Health Department. The matter has been heard at length. However, in respect to WPC numbers, which one?
Item number 3 and item number.
No, what is that case? Walpara, Narayan Nagar? In WPC, however, in respect to
8220.
WPC number 8220/2020, as well as
Joint Hazarika, 193120.
Item 12.
Item 3 and item 90.
where is joint Hazarika? Wait,
Item 12. man.
item Dimple Talukdar.
One 1931
Huh?
1931
You have not given that list with this joint Hazarika business.
Joint Hazarika did not copy. I think he has given
I've
there.
given you.
Not Lakhimpur.
Joint Hazarika is Dibrugarh.
Dibrugarh, sorry, Dibrugarh. man.
Dibrugarh, I don't have it.
1931/2020.
No. Dibrugarh. However, in respect to so and so, the earlier matter, and in WPC number 1931/2020, the Learned Counsel appearing on behalf of the Health Department submits that he may be given further liberty to look into as to whether there is any executive instruction which require that the administrative department needs to be informed prior to issuance of the advertisement or before conducting the selection procedures. In terms with Rule 5(3) of the, what is this rule?
Some direct.
In the Assam Public Services Direct Recruitment to Class 3 and Class 4 posts, Rules 1997,
Yeah.
page 115 of the-
Assam Public Services bracket direct recruitment to class 3 and class 4 post rules 1997. So this is in 1997. Then also.
2005.
1997.
The Learned Council for the Health Department further seeks to apprise this court on the next day as to whether there is any executive instructions which mandates that before issuing the appointment letter, the approval of the director or the administrative head
Yes, of the government, government in the
or the
health
government is required in terms with the said rules of 1997. This the matter as part heard on 25th,
Obliged.
25/5/2000.
Much.
Take it up, I'll write it. Write it. ইয়াৰ লগতে লগাই তোৰ লগতে লগাই দিব এইটো চেক কৰি ৰাখক পাৰ্থৰটোৱে
Chief Advisor.
Item 14,
Thank you, Your Lord. Lordship, I am appearing on behalf of Mrs. Rita Devi, Lordship. Please start up in the Lordship in the civil court, Lordship. The matter may kindly be taken up at 2 o'clock. We requested me, Lord.
What is this matter about?
Mr. My lord, cancellation of appointment, my lord.
Huh?
I am appointed, my lord, as per rule, my lord, DSF in constable. Later on, my lord, cancelling my appointment without showing any reason. This 23, 24 is the order of this court.
Your appointment has been cancelled.
Yes, my lord. Yes.
Why?
First, my lord, firstly, they were submitted that there is some discrepancy found in the appointment letter. Therefore, your appointment has been cancelled.
No, without giving you opportunity.
Yes, without giving me opportunity. Thereafter, I filed a petition, my lord. Kindly see the cancellation letter, my lord. Cancellation letter is, my lord, in from it start from, my lord, 99, page 99.
99.
Yes, my lord. 99 to page 104.
Cancellation of offer of appointment. You have been appointed.
My lord, proposal of appointment proposal was given to me, my lord. I am going for joining the head office, my lord, at Post Bihar.
They didn't allow you to join.
Thereafter, they give me the cancellation letter, my lord.
I am directed to inform you that a merit list for recruitment to the post of constable tradesman have been cancelled due to some discrepancy noticed. Consequent upon the cancellation of the merit list, the offer of appointment issued to you by above reference be treated as cancelled. Press list will be circulated and uploaded here. Accordingly, press offer of here will be issued later on. Now show me your appointment letter.
Appointment letter is, my lord, previous one, my lord, page 72.
Huh?
Start from page 72, my lord. Proposal of appointment,
How many person?
6%. It's a Hindi, but it's translated to
Page 72. The proposal for appointment of so-and-so in border security force. Governed by the BSF Act of so-and-so as so-and-so first 2 years, you will get the salary and year, though the service is temporarily, possibly it will be made permanently.
page
The
57,
temporary
it's a, my
service
lord,
will be dissolved, then your service will be automatically dissolved without any cause. If you go for any other service in 10 years, not recognition will be paid your total. Now, did you submit the character certificate?
all are submitted, my lord.
No, was there scrutiny done?
All scrutiny is done, my lord. After scrutinization, they have
Wait, how do you know that? The scrutiny was done in terms with clause 8.
my lord, there is all yes, we are my lord, we are similar person, my lord. 4, 5, all are appointed, my lord, except the petitioner.
All other 6 have been appointed.
Not on 6, my lord. There is one. Please kindly see the list, my lord. List of selection list. The
Where?
previous one.
Huh?
Page 70, my lord.
70.
All in the list are going with same condition, my lord. They are appointed. We 6 are, my lord, excluded.
This one. This
Yes.
was the appointment by which you were appointed.
These are the selection list, my lord. Page 70. 70.
Mitango Baro. Where is his name?
Mitingaboro is, my lord, in first row, my lord, last one. 6, number 6.
Ah, got it. Hey, yellow है तो इतनी option है तो. Ah. Then number 2,
Then, my lord,
Satinder Ramsuri.
Satindra Ramchari is, my lord, in the same row, my lord.
Number 3 is Sanjay Swaragi. Where is number 3?
Number 3.
Hey, yeah, got it. Number 4 is Solindo Daimari.
In 2, my lord. Second row, 2.
Ah. Number 5 is Hiten Deka. Where is it?
Last row, my lord,
got it.
7.
Number 6 is Mafizul Ali. Where is it?
Mufizul Ali is, my lord, in, my lord, the third row, second.
5th row. 1, 2, 3, 5. So number 2 is Anup Kolita.
No, my lord, from the beginning one, my lord, 1, 2, 3, third row.
3rd
second.
row. Ah, got it. Above Sanjay Swargari.
Yes, sir.
Okay. Now this is the appointment order. The
Selection
select
list.
list.
Selection.
Chalo. Now you say the other people have been appointed.
Yes, sir. All are,
Was there any press merit list issued?
yes, this merit is issued, my lord.
Where is it?
This merit is, my lord, in case 105.
105. And your names were not there.
My name was there, but my lord, not selected.
Oh, no. You were not there in the select list. Oh, those two.
Yes. Case 105 is 1, my lord.
So those who were selected were appointed.
Yes.
So there is nothing to that effect
Right.
that a person whose name was there in the first merit list was being appointed, except unless they come in the second merit. It is who came in the second merit list will only have been appointed.
My lord. Later on, my lord, second.
Only the second merit list. The appointment was never made in terms of the first merit list. So there is no discrimination on that aspect.
My lord,
Your issue, therefore, is that once I've been issued the appointment proposal for appointment, I have gone out there and now they are not allowing me to join. Is that your case?
My lord, before my lord, finalizing the case, my lord, there is the previous petition filed by this petitioner. Sir. This order is in case 24. If I go to this order, my lord, that will be better clear.
Yes, tell me what is your case? This one.
My lord, in the last, they are explaining, my lord, last relevant portion. As per
Before the
their-
petitioner could join as constable tradesman in so and so as per the selection and offer of letter of impugn order it that came to be issued by the deputy so as separate identical orders were issued in respect of it and were informed that the merit list for recruitment to the post of constable was cancelled due to some discrepancies. No. After cancellation of the evening, respondent number 5 to 11 was selected and offered appointment. So the petitioner issued notice on the took up with the cancellation of selected eight Yes. Then
My lord, thereafter, the executing department, I submitted representation and executed the representation and final order was passed in case 28.
28.
Next.
Yes.
My lord, kindly see, my lord, para 5 and para 6 of the my lord, execution of order. As regards the unfilled vacancy, only 6 vacancy are available. My lord, so will remain unfilled due to non-availability of the so. In our post, there is in our applying, my lord, category, there is no post as per their person. There are 6 in view of the fact enumerated above, the petitioner are otherwise not entitled of the advantage of their selection, which was found to be erroneous so and so and so. Well, kindly see the next advertisement. Here advertisement in page 57. Oh, sorry, ma'am. Page 42.
Where?
Page 42, ma'am. Page 42. Advertisement.
Yes.
In the advertisement, my lord, in the note, my lord, 1, they are saying that vacancy are subject to change, may increase or may decrease.
Where?
In the note, my lord, case 42,
Vacancies are subject to change, may increase or decrease.
my lord,
Last date 30 days from the date of publication of this advertisement in the employment. Yes.
my lord, as they are advertised such that, my lord, we are selected and we have required my required number, my lord, passing mark. Therefore, they are not considering mark, I lord, our post.
But they are saying that those people got more marks than you. They are saying these people have got more marks than you. Who are appearing for the private respondent? Notice issued.
Yes, not issued, but not accepted.
Who is appearing for the private respondent? No mention, nothing with regards. What about the private?
In the
The council
my
is a
lord,
big problem.
my lord,
Private respondents are not represented, na?
respondent number 6 to 12 are private respondent, not represented.
Then without them participating, how can they be not 3 to the 6 to 12?
My lord, 6 to 12.
I think you should take first step. Because here it shows it has come back. Notice were issued upon respondent number 6 to 12 by registered post. Unserved notice received back from the state respondents are kept in file act. This should have been seen. After 7 years, we are looking into it. But how can we set aside the appointment without hearing them? Isn't it? Hello. Our Mr. And so appears on behalf of the petitioner. You are the Common Council? Mr. A. Tapilda appears on behalf of the CGS. It appears that from a perusal of the petition that the petitioners have sought for cancellation of the second select list whereby the respondent number 6 to 12 were appointed, amongst other prayers. It further appears that this court had issued notice on 2/5/2016, and steps were directed to be taken upon the respondent number 6 to 12 by registered post with AD. The office note shows that although steps were taken and notices were issued on 30/5/2016, but there is an office note dated 29/8/2016 which shows that the notices issued upon respondent number 6 to 12 by registered post were returned as the same have been received back from the rate have been received. It further appears from the records that there is no orders passed as regards the service upon the respondent number 6 to 12 thereafter. Considering that the presence of the respondent number 6 to 12 would be necessary, this court further directs the petitioner to take steps upon the said respondent. Madam, you are appearing for the Inspector General of Police or something, BSF?
Yes, Lord, sir. For the official respondent.
Now, respondent number 6 and 12, 6 to 12 are working under you.
Lord, sir.
How do we get this notice served? You know where they are.
Yes.
This was filed in 2016.
Yes.
Now you may not know where they are.
Yes, sir.
So it be routed through you.
Sure.
He will give you 6 copies, you get it served.
Sure.
I think that is a better option.
Better.
Huh? Irregular last line too. Number 6 to 12 would be essential for deciding the instant dispute. This court inquired with Miss RDB. RDB. The learned counsel appearing on behalf of the respondent number 1 to 5. As to whether the service could be effected upon the said respondent number 6 to 12 through her, taking into account that the respondent number 6 to 12 are presently working under the respondent number 3. Working under respondent number 3, na? Inspector
it has
General.
to be verified, Lordship. It has to be verified. Yes.
They are working, obviously.
Lordship.
They are working under respondent number 3, or even the Director General is not required, but they are working
Yes.
under Inspector and respondent.
Yes.
The learned counsel appearing on behalf of the respondent number 1 to 5 submit that the service could be done so through her. So that the extra copies of the writ petition be processed through the respondent number 3 to the respondent number 6 to 12.
Sure.
Taking into account the same, the petitioner is directed to serve 6 additional copies of the writ petition upon Ms. RDB. The counsel appearing for the respondent number 1 to 5 by Monday.
Monday.
Today is what?
Tomorrow itself. I have no.
By 19th No, I'll give you time by 22nd May 2023. Ms. RDB, the Learned Council shall forward the same to the respondent number 3, who shall ensure service of the extra copies upon the respondent number 6 to 12. The respondent number 3 or through a person authorized by him shall file an affidavit to the effect that the extra copies of the writ petition has been served upon the respondent number 6. If the matter again on, we'll fix it in July. 18th of July.
At note 15 to 24.
This matter is said by Gan Chaudhary.
Hmm?
This matter is said by Gan Chaudhary. It is a lake at court number 2. Kindly pass for the private.
Don't worry, we'll hear the respondent and dispose of. If it doesn't come. Yes, Mr. Nayak, what is the case?
In this case, sort of petitioners are contractual employee of GMC.
GMC.
Yes. Here, some of them are engineers, some of them are assistants, some are field workers. But they are paying for regularization of their service. All of them were appointed subsequent to 2015. That's a problem that is there. Is
how can this court grant regulation?
No, Lordship, fact is completely different, Lordship. Lordship, what happened in the year, Lordship, I have taken.
What are you asking for? Let us see. When so, tertiary should not be issued to set aside quash the impugned communication dated so and so issued by the commissioner. What is that communication? 34/2022. What is that? Got it. With reference to this, I have the honor to herewith present a cadre and vacancy and syllabus for direct recruitment to the post of assistant imam. So these are the posts. So they want to set aside this.
Yeah.
No, Lordship,
You are asking for set aside cost the impugned communication dated this one. Then mandamus should not be issued directing not to appoint any person to the post of junior technical officer in the Guwahati Municipal Corporation. Mandamus should not be issued directing the year to honor and implement a conscious decision taken in the meeting held on demand for regularization of the services of the petitioners to the post of the junior technical officer in year with consequential benefit. Where is the decision? Let us see. Is the decision 26/1/2021. Where is
that letter, that minute they have not annexed.
No, Lordship, I have annexed in item number 22. Lordship, kindly take
item
up
number?
22.
Show me 22.
Annexure O, Lordship.
Annexure?
O. Case number 159.
Annexure 4.
159.
159.
159.
Yes. Who are there? Resident Conference Hall in the Honorable GDT. Honorable GDT had directed the Commissioner GMC that the regularization will be based on educational qualification in face balance. To submit detailed representation of the structuring pattern mentioned in our detailed here. Now what do you want to do? You want this to be done.
Yes, Lordship.
These 1607 posts should be regularized
No,
in
Lordship.
terms with what the minister said.
Yes, Lordship.
So go to the minister. What
Lordship,
is
no,
this court going to do?
Lordship, no, Lordship. As per minute dated 26/1/2001, already 500 employees were regularized. Lordship, kindly come to page number 162, Lordship.
Understood. Those 5% have been regularized. Let us appreciate.
Yes,
Those have been done. So go there.
Lordship, in pursuant to the Lord, kindly take up this matter at 2, Lordship.
I'll take it up there too, but you have to understand what are you going to argue at.
Yes, Lordship.
Think about in 45 minutes when you are having a cup of.
Lordship, may I say, Lordship, in this case, though we are receiving some instruction, Lordship, these are all piecemeal instructions. Lordship, I have already asked them to furnish me a complete parawise, Lordship. That we are not providing till now.
We will look into that later on. First and foremost, let us see whether the petitioner have a case.
Yes.
If the petitioner doesn't have a case, what are you going to do?
Okay.
Your simple question is this court can't direct regularization. Isn't it?
Yes.
And if this court can't direct regularization, where is the question of staying any appointment or any advertisement?
Okay.
Isn't that your case?
Okay.
At the end,
Here, advertisement has been issued, Lordship, and
now
some-
they will try to impress upon this court that Koshal's judgment, the minister says something, then
No,
also
Lordship,
it is
not only
binding.
Minister, Lordship, the authority has take decision, and Lordship, here 2 or more petitioners are appointed on compassionate ground.
Madam, let the government appoint whomever they let them do. But for this court to direct appointment, it's very difficult. In view of the judgments of the Supreme Court in the case of Uma Devi and all this, how can this court direct? Unless I dismiss, the division bench dismiss, you go to Supreme Court exercise 142.
Lordship, one judgment
And
I
by
found,
that time, Mr. Nayak will get his instructions. Till when the matter is there in the Supreme Court.
so far as the judgments are concerned, Lordship, that I can arrange in the meantime.
You get your thing.
Lord.
Team nurses. Now they were all appointed on contractual basis. Now there was an advertisement issued. At that point of time, the minister out there, the health minister, along with the principal secretary health as well as the director of mission, had a meeting and it was minuted. After doing so, they claimed they duly participated in the said advertisement, and in that minute it will saying that they will also be taken up for, they will have a committee who shall look into those aspects of the matter, and then they will give up a recommendation, and these people will also be brought within the fold of the general the health department. Now, pursuant to what has happened is they participated in the selection process. They did not get through, so they challenged the selection on various grounds, which I have negated. But as regards the representation on which they claimed their right to be considered or brought within the fold of the regular administration, I said that they have a legitimate expectation in view of that particular document, and for which I asked them to submit a representation and asking the chief secretary as well to consider that aspect of the matter. Wouldn't this case come within the ambit? More so
My
when
lord, in this case, I do not know what the other side has submitted, but according to our instruction, my lord, he has been asked to pray for some time, and the process of regularization is going. That is the instruction. A letter has been issued to him on 6th of May 2023. I do not know whether he has placed that letter or not. Now the corporation is seriously, my lord, contemplating to undertake the second and third phase. First phase, they have already done it. Second and third phase, they are going. That is what we know. That's what that's the.
Now, unless the case you permission is let the matter to be kept pending till they take a decision.
No, my
it's a
lord,
different
I think the letter which has been written to my learned friend is that he should pray for reasonable time from the court, so that in the meantime they may pursue the process.
Yes, that letter is there, Lordship, and today morning we informed them also, Lordship, but they had objection, but they were ready for hearing, they said, Lordship.
Good question. No. I think there's some miscommunication. I think my junior thought that they are trying to take adjournment. That is
in that adjournment.
so my learned friend informed my friend that they would
Is the GMC in taking steps for regularization?
One letter they issued to me, Lordship, there they have stated that they are trying to recruit the vacant post by following the procedure of law. That is one. At the second line, they said, Lordship, therefore requested to take appropriate steps and intimate the Honorable Court that completion of regularization process will take some reasonable time, and therefore High Court may be grant time as required.
So you are contemplating regularization?
Yes.
It is not there, Lord. It is not said there. They said completion of regular process will take some time, some reasonable time.
Therefore, completion of regularization process means you are contemplating regularization.
There, what they are intimating me, Lordship, they have not decided anything so far as the present petitioners are concerned. So,
As regards whom they have done?
No, one policy was there. Policy, I mean, during the last government, Lordship, one policy was there. In terms of that policy, 500% have been regularized. They are there, Lordship. But so far as the scheme, Lordship, that scheme itself says regularization will be within the I mean, one word was used there, Lordship. I mean, if they were appointed against regular post, Lordship, they may be regularized. That line was there.
So against sanction post, they will be regularized.
If some of them are working against sanction post, probably their cases will be considered. That was the intent.
But your instruction otherwise shows that they are in the contemplation of regularizing, and therefore that is why you are asking for time.
Lordship, this is contradictory. First paragraph and second paragraph are not telling, Lordship. In the first line, they are saying that has decided to fill up the vacancies following the due procedure of law, considering its financial implications and other related issues. One line is that, Lord. Second line, Lordship, regularization will take reasonable time. So, what is their actual intent, Lordship? That is awaited.
So what to do? These are matters of 2022.
Yes.
Yes.
Is there any stay?
So far as that appointments are concerned, Lordship.
There is interim order.
Yes. That last is your Lordship.
So the department is not concerned with the interim order.
We are concerned, Lordship.
You know, otherwise why you are asking for time? See,
Lordship,
so that you ask the court for some more time.
Yes.
Isn't that the fact?
So far as regularization issue is concerned, Lordship.
Understood. So you are not filing any application for vacating also.
No.
And this is your instruction.
That is the issue. For us, Lordship, that is the dilemma. We are not getting detailed instruction. Otherwise, it is not easy for the authority also to take such a decision, Lord.
Understood. Well, authority to take a decision or not, absolutely it is within the domain of the authority to take the decision. It is not this court for those court to direct. Because for this court to direct, meaning thereby on the basis of the minutes of the meeting, there is a vested right, which this court finds it difficult in view of Rule 10 of the Assam Rules of Executive Business. It is difficult to do.
Well, in case of corporation, is the corporation who has to take it.
Definitely, but you are right. You are claiming on the basis of the 21-6.
No, that was a minute method where it was, I think, minister concerned was there and other officers of the corporation.
So it is on the basis of that you are claiming.
In fact, partly it has been implemented. 500 has already been in the first phase. Second phase, my lord, the committee was constituted. Then thereafter, my lord.
So out of 1607, now it is only 1107.
Exactly.
Lot.
500 you have done it from 1600.
Yes, yes.
Because the total was some 2600 something.
In fact, my lord, they have worked out this strength of, they call staff pattern.
You have not filed your affidavit also.
No.
No,
So then I will defer the matter. How much? How many months? 2 months.
Lordship, I'm praying for some more time so that they can decide. Lordship,
How
and
much?
give us a detail.
You tell me.
Lordship, I'm if
let it be 6 weeks, my lord.
Lordship, may kindly make it 4 weeks.
4 weeks or 6, no, okay, no, I'm not, I
4
thought
weeks,
you
4 weeks means it goes after vacation.
vacation.
So how much? But if you are in the process of regularization, then take some more time, 2 months.
That's
3
why I
months.
said, my lord, let it be 6 weeks. In that case, my lord, my director can place the record, sorry, the decision.
Heard Mr. K. Chaudhary, the learned senior counsel, assisted by and the P. Nayak, the learned counsel appearing on behalf of the GMC. Mr. P. Nayak have been informed by who? Who has informed you?
It's the municipal secretary, Guwahati Municipal Corporation.
Municipal secretary have been informed, have been instructed by the Municipal Secretary, Guwahati Municipal Corporation by the communication dated 6/5/2023. Stating inter alia that a matter of regularization of the contractual employees of the Guwahati Municipal Corporation is pending for disposal before this court. And in that regard, the corporation has decided to fill up the vacancies following due procedure of law, considering its financial implication and other related issues. Further to that, Mr. P. Nayak was instructed to request to intimate this court that the completion of the regularization process will take some reasonable time, and as such, to seek some time from this court. It further appears from the records that till date, although there is an interim order operating against the Guwahati Municipal Corporation, no affidavit has been filed. There is also no application filed for vacating of the stay. Taking into account the specific stand of the Guwahati Municipal Corporation, this court fixes this matter again on 25th of July, 2023.
Interim order will continue to take.
The interim order passed earlier shall continue till then.
Deep breath.
Right.
JMC would be at liberty to file their pleadings if so advised in the
And number 26.
Yes, what is your case? એના તો judgment detail જૂનું દેવી નથી. There's none appearing on behalf of the elementary. Only is Mr. P.N. Sharma not there? જૂનું દેખા. એના તો judgment keyboard detail not one of the જૂનું દેખા. જૂનું? itu report होना है. चलेगा report. तो judgment पे itu मुख खुला है. Hey, यार judgment to like 6427 of 2017. Delivered कितने को इतने? 17. To Hedina the two. Kutesh लेने? तो कहीं मिलेगा तो order है 15 February. कितने judgment? Yes, Mr. Talukdar. You were there in this matter.
I'm no longer in this case, but the brief has been taken, my lord.
Who was there?
Presently, one Mr. T. Gogoi appears, my lord, in this case. Earlier, my lord, he was there.
None appears on behalf of the petitioner on call. Mr. N.J. Khatani appears on behalf of the
Elementary Education Department.
Elementary Education Department. The instant writ petition was filed by 9 petitioners claiming the outstanding salary from March till the date of filing of the writ petition. It appears from the records, the respondent number 2, that is the Commissioner and Secretary to the Government of Assam in the Elementary Education Department, has filed an affidavit wherein it has been mentioned that the petitioner have failed to show any document that they were appointed on being selected by the concerned subdivisional level advisory board. In paragraph number 6 of the said affidavit, it has been mentioned that the appointment of the petitioners were void ab initio, as if they were made in violation of the statutory rules. And as such, the state is not bound to pay the salaries to the petitioner. It is further relevant to take note of that after the filing of the said affidavit in opposition on 23/11/2010, the petitioners have not refuted the same by filing any reply. The question therefore arises is as to whether this court, when the fact pertaining to the legality of the appointment is in question, legality of the appointment is disputed, can this court issue a writ in the nature of mandamus for payment of the salary. In the opinion of this court, that as a fact, as the question as the facts pertaining to the legality of the appointment of the petitioners are disputed, and there being no denial to the specific statements made in the affidavit in opposition, this court is not in a position to ascertain as regards the legality of the appointment of the petitioner. Appointments of the petitioner. Consequently, the question of issuance of a writ in a nature of mandamus to compel the respondent authorities to pay the salary cannot be made, cannot be issued. Accordingly, the petition stands dismissed.
I appear for the finance department here.
I work with the info packet.
I'm okay.
Mr. Arvar Pujari, kindly look into this judgment. I made this one. Although I dictated, you were present out there. I made some internal, I've added some things. You may get next.
27.
Hell,
Yes. Yes.
what is it?
Pencil
Case about?
matter, Lordship.
Now be issued quashing the impugn order dated regarding cancellation of the earlier order by which the petitioner was transferred to Guwahati Iman as matron with immediate. Challenge to a transfer order.
Yes, Lordship, 2013.
None appears on behalf of the petitioner on call. Mr. D. Upamanyu appears on behalf of the Health Department. The challenge in the instant petition pertains to an order dated 28/2/2013, whereby the earlier order dated 21/2/2013, by which the petitioner was transferred to Guwahati Medical Hospital as matron, was cancelled. The learned counsel appearing on behalf of the Health Department submits that the transfer being an incidence of service, nothing survives in the instant matter after a passage of 10 years. Consequently, the instant petition stands dismissed.
Obliged.
Consequently, as transfer being an incidence of service, a period of 10 years have already elapsed. Nothing survives in the instant petition for which the petition stands dismissed.
28 and 29.
Yes, madam. What is your case?
Discharge from service.
Why there are two petitions?
Two different persons. One is the cashier, another is the grateful employee.
Huh?
One is cashier and another is grateful employee of the bank. So both of them were.
One is cashier. Who is the cashier? The richer one.
Gautam Acharya.
Cashier is Paresh
One.
Chandra Namashudra.
Paresh Chandra Namashudra is the grateful employee.
Is the bank?
Grade 4 employee.
Grade 4. And the other is the cashier.
Cashier.
Both of them. Okay. Which case should I take up first?
Lordship may take up the Gautam Acharya, the cashier.
Okay. Tell me what is the case about?
My lord, what had happened?
What are you asking? Discharge
Discharge.
of the petitioner from service with superannuation benefit for misconduct.
My
Okay. So you have been discharged.
discharge. Now, my lord, although my lord, pensionary benefits and all were given, but these were all my lord, adjusted against the pending loans.
Show me that order of discharge. You are challenging.
Is that page 54?
Hmm?
Page 54.
54. Okay. This is the appeal. Page 55 is the appeal.
Appeal. Page 48.
Punishment order is at page 49.
48 is the type of.
What was your age at that point of time?
42 at that point, at the time of commission of the incident.
44 years when you filed the writ petition. Tell me, what is wrong with the finding?
My lord, what had happened? He was working as cashier. He was working as cashier in that bank during 2009. The incident occurred in 2009, May 2009 to be precise. The case was that there was certain, under the scheme of some agricultural scheme, certain amount was to be released to some 40 of the beneficiaries. The allegation is that he was supposed to disburse 12,000, but he did not disburse the entire amount. And although withdrawal slips were there, he did not pay them the entire amount. And some of the amount, 6,000 was paid, and the rest 4,000 was misappropriated with, by 3 persons.
By?
3 persons.
4,000.
4,000 was misappropriated, 40 people. So 40 people, 2,41,000 was misappropriated by 3 people. And the ratio they have determined to be 30%, 20%, like that matter. So according to them, what was the amount misappropriated by this petitioner was 66,000. Then before formal complaint, he was in fact taken, physically lifted by the vigilance committee, and they took undertaking that yes, you give an undertaking that you have misappropriated this amount and will return this amount. That was thereafter taken from him, 66,000. Thereafter, my lord, a complaint comes in the month of October. The incident occurred in May. October, a formal complaint comes from a Gaobuda. Gaobuda alleges that there was some, the entire amount was not paid to the beneficiary, and that was the complaint. So, on the basis of that complaint, they started the inquiry, and then allegation of charges were brought against me in the year 2011, March 2011. So there the allegation is, if I can take your lordship to Annexure 2, man. Page 18.
Yes.
During your tenure as CCG of Bank Rajabazar.
What is CCG?
This is cashier.
Okay, cashier.
So
you have committed the following irregular acts. 40 numbers of borrowers of so and so had tendered withdrawal slip for withdrawing money from the respective after 30th of the month. Their accounts were opened by about 10,000 at the time of disbursement of 14 months. Okay, then
So, my lordship, may come to the next page 19. Doing page 19 of the same
Okay.
chart. Page 19, doing any act prejudicial to the interest of the bank or gross negligence or likely to involve bank law. Now, there is, my lord, he is charged with that. It may cause likely, it may cause prejudice to the bank. He has already.
Madam, can you see your
It is
mic?
not working. It is not working.
It's not working? No, it is working. But otherwise, I don't hear anything. Yes. Then speak a bit loud.
So, so this amount, what was alleged to have been misappropriated, has already been paid. Whatever, according to them only, he has refunded that money. So no physical loss has been caused to the bank. Well, now I understand that he is a cashier and this argument may not work, that there was no loss to the bank. Now, if your lordship comes to the other part of it, that how the inquiry proceeded, the man who complained, the Gaon he was never examined in the proceeding during the he was never examined. All those people who were the beneficiaries who alleged that they received less amount, none of them were examined during the course of my disciplinary proceeding. Their signatures were not verified, and
Madam, are you turning the disciplinary inquiry into a criminal court?
No, but basic requirement.
There's no denial of the fact you have deposited the
But he said
66,000.
it is under duress. I had to do it to save my job at that point of time. No disciplinary proceeding was.
Where is your reply?
Yes.
Where is it?
My lord, I can take your lordship to the written defense. It is at Annexure 5, page 31.
Page
31 of the written.
Yes, this is written argument.
Written argument.
No, where's your reply? Written argument, you make many things. Not only, where's your reply?
Reply is not input. Reply is not input.
Then
It is the written argument.
your reply makes all the more difference.
Right.
Because written argument, when you are giving, you have now the help of all your people out there, of your defense analysis or whoever it is. This is given by the defense representative. Where is your reply?
Reply is
But the fact that you have taken and you have replied, given out there, makes it clear. Unless you show it from your reply that I was given, I have paid under caution.
this is there in this written argument.
No, written arguments will say many things. It has nothing, written arguments, a person can say many things. I'm not on that. Once you know that these people have not brought those people out there, therefore your written argument becomes all the more better. Written argument won't help it. The reply should be. Let us see how the inquiry takes it, because the inquiry also does not say allegation as so and so letter of charge and so, wherein he understood the content and also whether he was accepting the charges against it. He replied that he has understood the content of the letter, but he is not accepting the charges leveled against him. Of charges to on the corroboration of ME1 against the question number 2 that was at the and beneficiaries were sanctioned MTF loan of Iman. Also established on account was covered by balance. On the deposition of the because your only thing is, as could be seen from the inquiry report, you have stated that you have paid that amount money and you have written out there under duress. These duress happened 2 years. Why haven't you done anything as against the 2 years?
That was the, in the appeal also, they have taken up this, that why you didn't do anything during 2 years. Because that time, my lord, no disciplinary proceeding was initiated.
Understood, but the moment you are caught out there, you say that, okay, I'm signing it. Once you are signing it, you have given, then you thought that, okay, I'm fine now, I have no problem with anything, I have already paid, matter is over. But are you saying, madam, a person who is a cashier, I would have understood the grade 4. A cashier who is in charge of this money, who is to disburse these amounts which are being given by the government to those persons, these amounts out there would not be, that person concerned would not be, is not responsible. A slightest, and more particularly in a bank matter, slightest of this misappropriation is a case for dismissal.
My lord, it
And
is-
here he has only discharged you, giving you all pensionary benefit. What else?
my lord, pension.
That is why I wanted to see what was the age, because order looks something similar to a compulsory retirement. Now, compulsory retirement can't be given because a person does not has to attain the age of 50 or something to that effect. So he has given the future employment also. There is no problem. Nothing has to that. But after all, whatever you have done is, I think, that is too much. You're lucky enough. There are lots and lots of judgments when a person of a bank who misappropriates. It's a very serious thing.
I understand this much, but Lordship, it raises some doubt that why this complaint was brought after 5 months. If they have received money, that's the amount whatever they should receive. After 5 months, they raised complaint, and before that, the
Is there
inquiry
any bar?
no bar as such, but
Then-
in person, 40 people are receiving.
No, are you alleging vindictiveness against somebody?
My lord, we don't know what exactly
Then
happened that
if
time.
we are not alleging vindictiveness against somebody because it is done as somebody, why haven't you raised any complaint out there that this thing, first and foremost, you are worried now with a discharge being given out here at that point of time without affecting your pensionary benefits and all. You are now worried. But you were not worried when you were asked to repay the 66,000.
Him, a tiny employee.
Would a
is-
person who is otherwise honest would have paid the 66,000? And you know the scope of interference in a matter under 226 is
Then
very
this
limited
bank,
out here.
That part I understand. But there are certain things which are, make this interdisciplinary proceeding that cause prejudice as well as that this person who was the complainant, at least he should have been examined. That why he lost his complaint after 5 months, and what was it? Why did they accept this amount? They come to the bank, they accept that amount. They don't raise any issue. After 5 months, they raise issue that we received this amount. There must be some nexus with somebody else also. It's not that maybe, I don't know, maybe so that the person, some connivance was there, but it's not that it was so simple that he misappropriated and nobody knew it, and it all happened, and then he paid
Maybe
the amount.
it may have been that the immediate manager out there, he must have been in good terms with you, for which he said, okay, I will make this matter hush and disappear. You just pay this amount and matter would be finished. You are happy enough. Okay, nothing. 2 years you have down the line have said that it's okay. But then another strict manager came out and look here, this person has done all this thing. It is a very serious offense which you have done.
Otherwise, my submission would be that no loss is caused to the bank.
Huh?
No loss, financial loss is caused to the bank. Of course, it's
There are many judgments out
my
there,
lord,
madam,
as a
to the
lawyer, I
effect
cannot
whether
speak to
financial loss happens or not. You are after a cashier.
cashier.
Then how can anything happen to
But
the
my lord, some lesser punishment would have worked.
What lesser punishment than this? Tell me. You can't be kept in service after you have misappropriated some money, admittedly. Then where is the question of this thing, any lesser punishment? You can't be kept in the service of a bank after all. You want to become a peon, it's a different thing, which obviously you wouldn't have liked.
Actually, he was working as peon, and then he was promoted as cashier. He has said in his appeal that I have less understanding of English and all. Therefore, all these things happen. Whatever they're asking me, I have written, and I don't know English properly. He has taken this stand. Not that it's also his cashier.
Where have you mentioned out here in this petition, in the affidavit, that you didn't understand English properly? But this affidavit petition is in English.
This petition I have not taken.
Then
But, in the
you
charge,
can't make all
it
these
is-
excuses,
it is
madam.
argument.
So, Mr. Datta,
Lord, my learned friend is saying that there is no loss to the bank. Lord, there are so many decisions of the appeals court. If you pay the amount along with the interest, my lord, misconduct is not obliterated by paying that amount.
and what about the other one?
Other one, the same, he also had to pay the amount.
He also paid 66,000.
Not 66. Here
And what was he doing? What work was he doing?
he was paid for employee.
Grade 4, what was he doing?
The allegation is that the three persons, this Gautam Acharya, Paresh Namachitra, another person, the three of them connived to misappropriate 2,41,000.
No. What work was he doing? Grade 4 has many jobs, no? What was the work he was doing?
The next is, my lord, I am not representing, there is some other lawyer. Yes.
He is described as sub-staff of the bank.
Here the statement of defense is here. The next method. Next 5. Astonishing to note that I have been subjected to an unpleasant situation for alleged action of deriving financial benefit for my personal gain by resorting to fraudulent action as referred in para of the letter under reference. It is not factually tenable considering my position in the bank as sub-staff. It will be unkind to frame me in the affairs as mentioned under para 1 of the state letter. The whole process involves operational work of the branch which is exclusively handled by officer and clerical staff as simply as a sub-staff. I have no role to play in the operational and accounting parameters of the event. As sub-staff, my function is strictly confined to perform job of a bearer. So attributing my involvement in the matter is also not true. Whatever mentioned in para 2 of the I have. Here the case is different. It is also not true whatever mentioned in para 2 of the said letter. I have not refunded or deposited any amount to replenish any shortfall as alleged arose out of the transaction. As a sub-staff, I was not concerned with any transaction of customer directly or indirectly. So refunding or depositing any amount is completely out of question. I affirm that neither I was involved in the matter as referred under para 1 anyway, nor I refunded any deposit. So this is his specific stand. I inquiry report was allowed 30 for submission of the written argument. Tenure of 20. In reply to the What is CSC?
CES, charge sheeted employee. Charge sheeted employee.
Oh, what is the second person doing now?
He's also out of job.
Understood. He's getting his pension.
Pension, but it has all been adjusted against their loan, some outstanding loan. His already the appeal still remains pending. His appeal still remains pending
Appeal what?
against the.
My appeal against so what happened to his appeal? But what is your main case? Should this court go into those facts, which this court can't touch it?
But my submission would be some lesser punishment. Taking that.
What lesser punishment? In the other case, there's no question of lesser punishment.
Now,
In this
now
case,
my lord, since now almost 9 years have gone, we are now being engaged by the department without any for the other benefit. Let them consider my can be if this order is interfered with. The packages and all not being right.
Madam, what is happening out there, more particularly in these banks out there, and these loans, as regards these housing loans and all these things, people are preparing, these bank people in collusion with all these people are opening bank accounts in the name of fake benefit. While I was a lawyer, I was doing a particular matter pertaining to this SBI thing. They have this in certain places where the SBI doesn't have branches, they have a particular unit. No? They have sub-delegated to somebody. Now, this person concerned, he opened up some 1,000 accounts, got entire money. Then one fine day, when the bank goes to see where are the houses out there, they found it was those people were actually, in whose name those people were believed in Jhum cultivation.
Yes. In most of the cases, your lordship will find there is even no.
And there are nobody is there. And this is not a small amount my client was asked to pay something around 91 crores or something. This was the amount. Bank, one has to be strict. Otherwise, the discipline will go.
That's why, my lord,
And in fact, this person, Gautam Acharya, couldn't have come in contact with those people unless the conduit happens to be this person.
Exactly.
This is how things work.
The role of the officers of the bank, my lord, your lordship have find some.
He gets
decision.
him.
Could have been like Caesar's wife.
Huh?
The officers of the bank, especially account officer, cashier, the rule should be like a Caesar's wife. Even if there is some doubt, that is enough for dismissal or removal. Here, my lord, the first case, Gautam Acharya, there was a case of removal and or dismissal. But then leniently it has been.
In fact, in the first case, the first person gives the evidence against him.
Yes.
Against the second person.
Yes.
But both of them has the same lawyer.
My lord. Later on, they realized that both of them are in trouble.
Okay, I come in 5 minutes. I'll dictate the judgment. Question of law. It's paramaterial. A perusal of the repetition. Reveals that 40 numbers of borrowers of the bank, United Bank of India, Raja Bazar, Jaipur branch, had tendered withdrawal slips for withdrawing money from their respective savings bank accounts after credit of the closure proceeds of their related, what is RIP?
Reinvestment plan.
Reinvestment plans. The related reinvestment plan saving bank account were opened for rupees 10,000 each. And at the time of this disbursement of the 40 numbers of agricultural loan proposals for rupees 30,690. The said loan accounts were closed under the inverted comma Agricultural Debt Relief Scheme 2008, whereby instead of paying the full amount written on the withdrawal slips of the related account holder, rupees 6,000 each was paid and the remaining amount was alleged to have been retained and shared amongst the petitioners herein in both the writ petition, along with another. It is further seen from the records that the total aggregate payable amount was rupees 4,61,867, and out of which rupees 2,40,000 was paid to the account holders. On the ground that the petitioners in both the writ petition along with another had misappropriated the amount of rupees 2,21,867. Both the petitioners herein, the petitioners in both the writ petition were issued charge sheets it is relevant to take note of that the petitioner number 1 was alleged to have misappropriated an amount of rupees 66,557. Petitioner in WPC number 1657/2013 was alleged to have misappropriated an amount of rupees 66,557. Whereas the petitioner in WPC number 3784/2013 was alleged to have misappropriated an amount of rupees 44,380. It was also alleged in the charge sheet that the petitioner in WPC number 1657/2013 upon being detected deposited an amount of rupees 60,000 512 and rupees 6,045 on 4/7/2009, 3/11/2009, and 7/11/2009 respectively. In the same vein, the petitioner in WPC number 3784/2013 was also alleged to have deposited returned the amount of rupees 12,000, rupees 28,350, and rupees 4,030 on 26/9/2009, 3/11/2009, and 9/11/2009 respectively. Although in the writ petition WPC number 1657/2013, there is no written, the statement of defense have not been enclosed. But from a perusal of the statement of defense of the petitioner in WPC number 3784/2013, encloses Annexure 5 to the said writ petition. The petitioner had denied that he was involved in any misappropriation and that he had returned the said amount. Be that as it may, separate inquiries were held against the petitioners in both the writ petitions. And the inquiry report so submitted, found the petitioners to be guilty found that all the charges leveled against the petitioners by the charge sheets in question was proved. It further appears from the records that pursuant to the submission of the inquiry report, the petitioners were given the opportunity, petitioners in both the writ petitions were given opportunities to show cause as regards the acceptance of the inquiry report, and the petitioners duly submitted their replies respectively. It further appears from the perusal of the records in WPC number 1657/2013 that an appeal was preferred before the appellate authority and the appellate authority by an order dated 26/6/2012 they reply কৰিলে নহয় reply কৰাৰ পিছত কি আহিলে সেইটো পিছলৈ আহিব। It further appears that both the petitioners in both the writ petitions were imposed the major penalty of discharged from service with superannuation benefits, that is pension and or provident fund, and gratuity as would be due otherwise under the rules or regulations prevailing at the relevant time and without disqualification from future employment. This punishment was so imposed in terms with clause 6D of the Memorandum of Settlement dated 10/4/2002. It further appears from a perusal of the records in WPC number 1657/2013 that an appeal was preferred by the petitioner therein a petitioner in the said writ petition before the appellate authority, and by an order dated 26/6/2012, the said appeal was also dismissed, thereby affirming to the penalty so imposed. However, in the case of the writ petitioner in WPC number 3784/2013, it is not clear as to whether it is not clear as to what is the fate of the appeal so filed by the petitioner, by the said petitioner. Yes, madam, any idea on the appeal? This court further inquired with the learned counsel appearing on behalf of the petitioner as regards the outcome of the said appeal. The learned counsel, however, submitted that she has no instruction in that matter. Next. Being aggrieved by the actions of the respondent bank in discharging the petitioners by imposing the major penalty as already stated here in above, both the writ petitions were filed. It further appears from the records that the respondent bank have filed affidavit in opposition in both the writ petitions. From a perusal of the affidavits in opposition so submitted, in both the writ petitions, it transpires that the specific stand taken is that both the petitioners have admitted to their guilt before the authorities concerned, and thereupon, on the dates so mentioned in the charge sheets issued to them, have returned or refunded the amounts It is the further case of the petition respondent bank that after following the due process, as well as the principles of natural justice, findings of facts have been arrived at that the petitioner in both the writ petitions were guilty of misconduct, and accordingly, taking into account the malafide and fraudulent acts of the petitioners who were employees of bank bracket and organization dealing with public money, the penalty of discharge without affecting the pension, without affecting the pensionary benefits as entitled under the rules and regulations, have been imposed upon the petitioner. In the backdrop of the above, let this court therefore take into consideration the respective submissions of the parties. The learned counsel appearing on behalf of the petitioners submitted, petitioner in both the writ petitions have submitted that the person at whose behest the inquiry was initiated was not examined. The learned counsel for the petitioner further submitted that the recipients of the benefits, or for that matter, those persons who have been deprived, were also not examined. And under such circumstances, the findings arrived at is not in accordance with law. The learned counsel for the petitioner further submitted that even assuming, for argument's sake, without admitting that the petitioners were guilty as charged, then also the punishment of the charge so imposed upon the petitioners was disproportionate. Anything else, madam? On the other hand, the learned senior counsel appearing on behalf of the bank respondent bank submitted that the scope of interference under Article 2 to 6 of the Constitution On the question of finding of facts arrived at in the departmental proceedings is limited and circumscribed. The learned counsel, senior counsel further submitted that there is a difference as regards how a proceedings, a departmental proceedings, as regards the manner of conducting a departmental proceedings as well as a criminal trial. The learned senior counsel submits that while in a criminal trial, the burden of proof against the accused is beyond reasonable doubt. But in the case of departmental proceedings, yes, what is it? Departmental proceedings, what is the
Preponderance of probabilities.
preponderance of probability? The learned counsel for the senior counsel further submitted that the respondent bank is a public organization, is an organization dealing with public money. And loss of confidence is one of the very important aspects which needs to be taken into consideration. Loss of confidence of the employer is a very important aspect which needs to be taken into consideration. While imposition, while taking into consideration, while imposing the penalty, the learned counsel, senior counsel further stated that in the instant case, the facts so arrived at by the upon so arrived in the inquiry report, as well as also the inquiry report, as well would clearly go to show that the petitioners were guilty of misappropriation of money by fraudulent and malefied means. And as such, the respondent bank had rightly imposed the penalty of discharge in service without affecting the pensionary benefits as would be entitled, as to which and the benefits to which pension benefit, to the extent the petitioner would be entitled as per the rules and regulations. Next. I've heard the learned counsels for the parties and perused the materials on record. The submissions so made by the learned counsel for the from a perusal of the materials on record, and more particularly the inquiry report, the order of punishment by the disciplinary authority, And the order of the appellate authority in WPC number 3784/2013 would go to show that a fact-finding authority had already come to a finding that the petitioners were guilty of misappropriation of the money of 40 of the 40 customers. Though it is the submission of the learned counsel for the petitioner that the money having been returned, the respondent, there was no loss to the respondent bank. But the fact that the petitioners work in an organization wherein people deposit their money an act of misappropriation cannot be allowed to be. Pardoned on the ground that the amount has been returned. This court is also conscious of the fact that the scope of it is also relevant to take note of that, except pointing out that certain evidence was not taken into consideration. There could be nothing could be shown as regards the perversity in the finding in the inquiry report, as well as in the order passed in appeal, in W appeal. This court also cannot be unmindful of the fact that the scope of judicial review in matters pertaining to disciplinary proceedings is limited, and since any perversity or materials which are extraneous or irrelevant being taken into consideration in coming to the finding, the scope of interference under Article 2 to 6 cannot be adhered to. Now, coming to the next aspect of the matter as to whether the punishment so imposed upon the petitioner in both the writ petitions were disproportionate to the charge leveled against them. It is no longer res intriga that when question as regards misappropriation when charges against misappropriation is proved in a departmental inquiry, it is required That too in an institution, an establishment, like a bank, where people, where public repose their faith. This court is of the opinion. Repose their hard-earned money. Public deposit amounts, reposing faith in such establishment. It would not be proper on the part of this court to interfere with the punishment so imposed upon the petitioners. More so, when the respondent bank, in view of the conduct of the petitioners, have lost their confidence upon the petitioners. Considering the above, this court does not find any merit in both the petitions, for which the petition stands, both the petitions stands dismissed. Yes, you got your file.
Somehow.
Ah.
30,
Mr. Doctor, can you ask your junior to give me one judgment on that loss of confidence?
Yes.
The term is loss of confidence. Huh?
Right, right.
Long
I
time
think I'm
before I
having-
did the matter. Huh?
I think I'm having it. I'll just.
Just give it to them. I'll just incorporate it in the because when it's a loss of confidence, you cannot touch.
Exactly. That point I'm having. I'll just.
Humanitu? Yes, Mr. Chauhan.
My lord, the departmental proceeding and my lord, punishment. And my lord, my sub,
Departmental proceedings, relief sought.
my first ground, my lord, departmental proceeding was my lord, illegal and without jurisdiction, because my lord, the charge sheet was submitted according to them. By testing on my gate in the evening when I retire on 30 of September 2010. And my lord, I was very much in the office. And my lord, I surrender my lord, the I card, proximity card, my lord, a SIM card, and my lord, handed over. And upon circumstance, my lord, received, my lord, I have next the document. So, my lord, according to my lord, regulation.
Mr. Roy, what has happened to that appeal?
Appeal has been disposed of, my lord, dismissed appeal. That order is not challenged. Put to challenge. Appellate order is not challenged, my lord. That's the, and there is a further provision of, there is a rule, in appellate order itself says, though it says that, my lord will kindly see last page, and the rule, it's like a second appeal, my lord. That is a statutory provision. You can still avail a remedy, you know. Under the statute.
But whatever may be, keeping the matter pending for last 10 years.
That's right. That is true.
Now remanding the
But
matter
then, but then
wouldn't be proper.
your lordship is right. But then the appellate order ought to have been, my lord, put to challenge, you know, that.
Then also,
My lord, appellate order.
I would have understood the appellate order modifying something.
That's right. That's right.
Then it would have been different.
That.
But anyways, yes.
My lord, appellate order was passed, my lord, by the person who was.
No, why you are challenging this order?
My lord,
Tell me, departmental proceeding.
My lord, I have challenged the departmental proceeding.
What is the punishment imposed?
My lord, forfeiture of rupees 4 lakh from the gratuity fund, my lord, and compulsory retirement with person already long back, my lord, retired.
So that is being useless only.
Yes.
You filed this writ petition, your age was 63 years. Okay. Now let us see the punishment order.
Yes, my lord.
Where is your punishment order?
116.
My lord, page number 160 to 166.
160. Order charges 1, 2, 3, 4, 5, 6. Therefore, the undersigned in exercise of powers under 56 hereby imposes a penalty of compulsory retirement from the service of the corporation with effect from so and so, along with forfeiture of his gratuity to the extent of 4 lakh in terms with so and so to partially indemnify the loss caused to the corporation. Now, this order was passed when? What is the date?
My lord, this order was passed on
24 September 2011.
Yes.
Now, when did you retire?
my lord, 30 September 2010.
So, compulsory retirement is useless.
Lord.
Now, we are concerned with 4 lakhs. The matter becomes easier. Now, show me why this 4 lakhs you should not be done.
My lord, my first submission.
I am Mr. Roy. I always fear 2 types of matters whenever it comes to this FCI or the central government organizations, and the second is as regards the central government matters. Their petitions becomes very thick because of such lengthy orders they pass.
My lord,
Because in long and short, the matter is otherwise short.
Lordship is right. It happens like this because the disciplinary authority,
Yeah.
in fear of being put in blame by the senior officers, they used to do like this. They go all out, so that the senior.
You know, today I was taking up one matter out there, some matter pertaining to some merit list being withdrawn and all these things. This court passed an order to that effect, and the reply and the consideration of order was 22 pages.
Huge, my lord.
Chala. Yes, why this 4 lakhs? Where is the charge of 4 lakhs?
my lord, 4 lakh.
Amount to the was paid to the contractor in civil work under the jurisdiction without execution of the work, thus causing pecuniary loss to the corporation. Whereas an
number
addendum
one,
was issued on so and so, making certain additions in. Now, when was the notice issued to you? Disciplinary proceedings,
My lord, notice, my lord,
articles of charge, 15/11/2011.
yes.
No, my lord.
Yes.
Initiated 2010 itself.
Huh?
2000 on the date of retirement, in fact.
My lord, date on the date of retirement, kindly see my lord, first my lord, page 30, lecture 2. This is my lord, my
My lord,
retirement order.
addendum was given later.
Page 30.
30, this is my retirement order.
Charge sheet dated command. Page 30. 30 is your retirement order. 2930. On attaining the age of superannuation of 60 years, date of birth so and so, Guwahati shall be relieved from the service of the year in the afternoon of 30/9/2010. Then,
My lord, page 32 is the important, my lord. Kindly see on 30, my lord. On being retired, my lord, I handed over everything. Kindly see page 32, my lord, lecture 3.
then
Taken over charge, my lord, handed over charge.
with reference to I am to be retired on date and following a return identity card, proximity card,
Yes,
SIM
yes.
card. Okay,
Yes, my
so you have returned and received. Then,
my lord, they have taken the ground that I was not available in the office on that day. It is why they could not serve me, my lord, the charge sheet. Which is, but my lord, they intentionally, my lord, avoid my lord giving time when I was not available. When they went in my house, they avoiding.
But my lord, this proved that I was in the office on 10th day.
Then
Then my lord, I received my lord the charge sheet only on 6th
Hmm.
after my retirement.
after your retirement, it is not possible.
My lord, the rule says, my lord, since I was no longer employee of the my lord FCI, so my lord, the rule does not support my lord department.
Show me that rule. Where is the rule?
Okay.
CBI inquiry is there.
Yes.
What happened?
Regarding charge number 3, my lord, or equated.
CBI has recommended for a regular departmental proceeding against him. That's why. After
When did the CBI recommend?
CBI, after the CBI recommendation, fresh charge sheet was issued.
When?
The CBI case, in the first charge sheet itself, there was a CBI report. CBI is already filed charge sheet earlier. Charge number 3 relates to the CBI charge sheet.
CBI cases, my lord, in both the cases, my lord, petitioner acquitted into 2020, December 2020.
Oh, that is there.
68, my lord, says only
Huh?
the case of my lord.
68. 68 does not stop you that after retirement there cannot be. Does it say so? Unlike we have in 21B proviso. In the rules of 1969, it categorically mentions that if you want to go ahead with proceedings after retirement, then you have to take the permission of the governor. Where is it? No, nothing to that effect. A disciplinary proceedings if instituted by issue of charge sheet while employee was in service, whether before his retirement or during re-employment, shall after retirement be continued and concluded by it, commenced in the same manner as if the employee has continued in service. Such proceedings after retirement should be completed expeditiously within 12 months from the date of delivery of charge sheet to the ER, subject to court's order, if any. The disciplinary may withhold payment of gratuity of
My lord, regarding retail, after retail employee, my lord, there's nothing else.
Where is the CBI thing?
CBI came, my lord, okay.
Yeah, affidavit in reply is also very bulky.
My lord, I could not submit my lord the judgment of the CBI because my lord, this is me, my judgment of the CBI, me, my.
What happened? You have been discharged.
My lord is acquitted. In both the cases.
You are acquitted.
Yes. Then one more thing, my lord, this person, my lord, as regarding charge number 2, the person, my lord, also responsible, my lord, for recommending the range of height of the, my lord, go down. He was then, my lord, executive director, Mr. Singh, and after promotion, he was, my lord, chairman, and being chairman of the, he could not have my appeal. He heard and dismissed the appeal, the same person. In para 12, my lord, of my reply, I specifically, my lord, stated the 6th number of
CBI report is noted at page 12 of the affidavit in reply given by the petitioner. From page 12 onward.
Of the affidavit in reply.
Yes, the petitioner has annexed, I find. page 12 onward. Final report, CBI.
What does he say?
He finds there material against him, but then for my lord, criminal liability, they found nothing. But then the entire report,
Then why they have brought him within that?
But CBI can file any, might make any litigation, my lord, anybody, but this is not the, my lord, final, my lord, verdict. The final, my lord, it is the order of the court. And based on my lord, state, my lord, CBI report, my lord, is the disciplinary authority, my lord. Post punishment. Paragraph 12, my lord, I specifically, my lord, stated regarding charge number 2. Charge number 2 was
AC Das, your name is AC Das.
not.
Page 50. What is RDA?
Regular departmental
Minor.
action. That's when CBI when finds no criminal liability.
On his part may not be sufficient to prosecute him in a court of law, but since the lapses are serious, causing loss to the FDI, recommended so and so. However, so and so are recommended for facing trial in the court of law, and charge sheet against him have been submitted. Necessary action, therefore, if any, against him in the department. So there was no charge sheet against him
By the department.
by the CBI
CBI only regular recommended RDA.
of RDA minor.
Yes.
Now let us see what is RDA minor. Procedure for imposing minor penalties. Subject to the provisions of the equivalent, no order of imposing any penalty of informing the bank in writing. When was this charge sheet given?
my lord, 6 after retirement, 6/10, 2010.
Huh?
6/10/2010.
The charge is 39.
So when is the charge sheet? Charge sheet has to be after this, because if you come to page 40, CBI report, there the date of retired on 39. So this is after retirement.
No, this report is, but the my lord, if lordship kindly comes to the chart, page 35.
Page
35 is the initial chart. 35.
Yes, what is it?
Statement
35 of what?
Read petition.
Understood, but
And
kindly
charge
come
number
to page.
3,
No,
charge
kindly
number
come to
3.
page 40 of the affidavit in reply.
That is all right, my lord. That is after the, that is subsequently, this is, there are 3, my lord, charge, I mean, initial CBI cases. In one case, it was started, first case, my lord, kindly see page 44 of the read petition. Page 44.
Yes.
A case number so and so dated so and so has been registered by the CBI against AC Das along with other officers file being posted in Regi 3 for misusing his official position. An amount of 8,70,000 was paid to the contractor civil work under jurisdiction of the DO Tezpur without execution of work and thus causing pecuniary loss to the corporation. AC Das has been found deeply involved in the following cases: irregularity of so and so, so and so, so and so. So based on this, in fact, in this case itself, the penalty was given. This case number 5.
Penalty has been given in which charge?
On this,
there are many charges. Charge number 3.
3. This is the charge number.
Article 3.
Article 3.
Let us see Article 3. Under this article, the charge in is therefore partially proved. Article 2 is partially proved.
Article 2 is partially proved. 3 is
Under this article, a mention has been made of 2 cases by the CBI against this year, along with the cases so and so also speaks of an amount of rupees demand paid to the contractor under the jurisdiction, along with 3 others relating expenses without exclusion of pecuniary loss. It is may also speak of an amount of rupees 1 lakh made to the contractor under the demand without exclusion. Though the officers of the CBI and the demand were listed as in demand for proving the assets of the system appeared like the consequence of the application. Now kindly come to page 149. The second paragraph.
The part of where 149 minutes, Lordship is reading the
Repetition.
part of inquiry report.
Yes, inquiry report.
Inquiry report. And that was the disciplinary was disagreed. And therefore, disagreement note was furnished given to him. And after receiving his reply, the impugn order.
So the inquiry report does not find him guilty.
No, that's the finding. That's fine.
The findings of the
charge number
charges
3
are
says the
not,
authority may take action. Did not come to any finding.
only
That's-
part 2 is true.
That's right.
Now then serving of the Iman in so and so disagreement note. Memorandum Charles so and so. Then
He has submitted a reply and then it was considered. After that, my lord, basically on charge number 3, the punishment has been imposed.
order charge number 3. A case of so and so whereas an addendum was issued on Iman making certain additions to the articles of charge.
My lord, charge number 3, my lord, inquiry officer finding is page 150, my lord. Page 1.
Mr. Chauhan, tell me whether the bills were passed by you.
Bill, my lord, regarding charge number 1, my lord, allegation is
I am on charge number 3. Whether did you pass the bills?
no, my lord. Charge number 3, my lord, can we see one page?
I am
number
not on that, Mr. Chauhan. You tell me only one thing. Whether did you pass the bills? Kindly come to 165. See that paragraph. The departmental proceedings are quasi-judicial proceedings. Read that. You dispute this.
My submission is that, my lord, regarding charge number 3, my lord, whatever finding is here, not based on departmental, my lord, inquiry. Because, my lord, there was no inquiry regarding charge number 3. Because, my lord, that is why, my lord, I like to show
Mr. Chauhan, you go to the judgment of the Supreme Court in KRP 1979, Constitution Bench judgment. More particularly in paragraph number 12, the Supreme Court says that an inquiry report, if it is given, the authority cannot say that we are not going to give any importance to this, and then after have another inquiry. But the reason why the Supreme Court says is because the disciplinary of authority can very well discount or remove, not take into account the inquiry officer's report and then pass orders. Your right is only to the effect that you are to be heard.
my lord, regarding charge number 3, my lord, no, because, my lord, no, my lord, witnesses stand, my lord.
Now you have issued a disagreement memorandum and you have replied to that. I'm only asking you a simple question because the scope of the 223 jurisdiction is very limited. Did you pass any bills in respect to certain works? Your specific 10 is I only look for this 10%. But did you pass any bill? Because the specific stand out there that there was no work at all.
My lord,
Where is the question of supervision?
my lord, the petitioner, my lord, always adopted, my lord, proper procedure. My lord, proper procedure. And that charge number, my lord, was investigated by CBI. And ultimately, my lord, if the petitioner faced trial.
CBI is different. CBI is beyond reasonable doubt. We are not on that. Did you pass a bill out there stating to the effect that any bill without any execution of work?
My lord, he passed the bill.
What is your reply to the disagreement memorandum? What is your reply?
My lord, I regard, my lord, the inquiry report, my lord.
What is after the inquiry report? There was a disagreement memorandum which you have enclosed to your petition.
Right.
What is your reply to that? You was given an opportunity to reply.
My lord, so far the charge number 3, my lord, I repeatedly demanded, my lord, document. But, my lord, before inquiry officer or anywhere, my lord, no document, my lord, furnished. By saying that everything is before the CBI, CBI has taken all the documents.
Therefore, I am saying, what is your reply to the disagreement memorandum?
My lord, my reply is 169, my lord, charge number. Charge number 3, dated member was based on the education made in the
169 is what?
One.
This is an appeal. I'm not on the appeal. I'm only asking what is your reply to the disagreement memorandum?
In the order itself, 160. Order itself, it is quoted, my lord, by the
Page?
Page 163.
And I replied that so and so. Let us see number 3. Has the following given the following contention in his reply. There was not produced by the PO during inquiry. CBI report should not be made prosecution documents as per the CBC manual. Annexures of the CBI have not been supplied to him. On merit of the allegation, he has replied, as per PWD rules are followed by FTA, 10% test checking is required to be done by the AGM civil. Since AGM is not sitting in the field, he cannot be responsible for 100% of the work at the ground level. PCS Das, his subordinate, has not been convicted by the CBI, so it cannot be concluded that the work were not executed. CBI report has been served on the CEO in interest of that so as to give him reasonable opportunity to reply to the allegations made in the CBI report and subsequently in the FCI charge sheet. But it is a decline to receive the lectures of the CBI report for petty reasons when a team of so-and-so visited his residence on remand. Earlier also, he avoided receipt of the charge sheet. So the charge sheet was served by way of pasting the same in his wall on when he is in the habit of purposely not cooperating with the FBI to take benefit of it. Then
I never avoided my doctor taking the.
you avoided, don't avoid. How this court is going to do? Go and file a civil suit.
So my lord, so by the observation that I avoided my lord, I my lord told the record my lord, I my lord very much there in the office, and I my lord handed over my lord whatever with me my lord, and I my lord I get my house my lord, and there.
Mr. Sohan, this court is not satisfied with those answers. I am actually asking you, did you pass the bill without any verification whether the work was done or not?
No. No.
You did not pass any bill.
My lord, whatever bill passed my lord, they were adopting my lord property.
So there was work done. Are you saying that the work was done?
What? Done my.
Huh?
What?
The work was done.
What?
Whether there was execution of work or not. Only limited question is this. If you have passed the bill without execution of work, then obviously you are guilty. If you have passed the bill after, if there is work, execution of work, you are not guilty. That is the only reason, isn't it, Mr. Roy?
Yes.
Only simple thing is that although the matter is so voluminous, we are on page 165. Why haven't you not enclosed your reply to the writ petition? You have given so many documents, but not the reply to the disagreement memorandum. Why? Was it too big?
Appeal my lord, I have taken.
Huh?
The appeal my lord, I have taken.
No, appeal, I am not bothered with appeal. I am only asking about that. In the appeal, have you mentioned that there was work done? Hello, I have to write now. Yes, Mr. Talukdar.
Subject to your lordship's permission, can I make a prayer in respect of item 32?
Yes.
It is a pension matter. Can it be on next Thursday, madam?
That is matter. Corporation Department. You wanted to do it on Saturday? Pension?
Pension.
What pension?
Well, in fact, pursuant to disciplinary proceeding, well, that entire pensionary amount has been withheld by the government.
So it is disciplinary.
In fact, it's a disciplinary proceeding, but consequential, my lord.
Consequential is pension, but otherwise it's a disciplinary. The disciplinary proceedings are on other days. Otherwise, with the pension, I can take it up on Monday, Wednesday, and Thursday. Disciplinary proceedings is. Mr. John?
Yes.
Well, when should I take it? Only on 165. The entire case hinges on 165. Nothing more, nothing less. When? It's a matter for further hearing on 23rd.
Well, two matters. What are the difficulties? Let it be on earlier. No, my lord. I
23rd. 23rd is Tuesday.
That happens.
Okay, this matter will reach
No,
me
no.
on 23rd. And your matter will have it on 25th.
Matter, it will be 25th, my lord.
Huh?
Thursday, 25th.
No, 23rd. You come up with this thing. You've heard you.